Um, we're not broadcasting to Houston yet. Okay, very fine. All right, just before we broke, I said I was closing the public hearing. I want to give the other appellants here an opportunity to rebut. So, Mr. Connolly, do you have any comments that you want to make at this point?
Mr. Chairman, I'll make mine very quick. First of all, I want to get back to the issue that I started out with, which is, I've never been in a Board of Supervisors meeting before where a banker gets up and indicates that if you make the right decision for the county, we are going to destroy Mr. Nemi. I mean, that kind of theatrics I don't think is appropriate, which is basically what I heard. No banker, no lawyer will stand up in a public meeting and say there's no purpose for it, it's not addressing the issue before the board. The simple issue before the board today is that you have to decide is whether or not, under your existing ordinance, agritourism allows golf courses. And the answer to that question in your staff report is no, it does not. So there's no purpose to that testimony other than to put pressure onto you to say, if you do that, we're pulling the trigger on Mr. Nemi. Now, if you do decide that you want to have golf courses on agricultural or AP land under the existing, which you can under the existing ordinances, that requires an amendment. And it requires an amendment of your zoning ordinances, which requires an EIR because of the obvious impacts that golf courses have on agricultural land. And it cannot be today that there's simply a grandfathering in pretending that the existing ordinances allow golf courses on agricultural land. It does not allow it. And your ordinance, as your staff has pointed out, is drafted in terms of the uses that are allowed under agritourism on agricultural land. There's also been a suggestion that was said by counsel in arguments that you can look toward your ag ordinance, and your agricultural definition allows some things in your agricultural ordinance that aren't related to agriculture. And that may be true. But those are there after you did an EIR that determined that you would, what the impacts would be, and you wanted to have those there. So the answer is the same. If you decide that golf courses are something you want under agritourism, it's a project. If you decide that you want to change your definition under agricultural zone of what's allowed in an agricultural zone, forgetting the agritourism argument, it's a project under CEQA. You cannot come in and impose mitigation measures on a project on this golf course at this point to try and band-aid it and say, well, I'm concerned about the traffic, I'm concerned about the water, because that's outside the normal process. You're trying to impose mitigation measures on something you've now just determined is an allowed use, a permitted use, not a conditional use under agritourism. And that is not allowed under any known legal procedure, and I'm sure County Council can confirm that. So our position comes back to this. You shouldn't be held ransom because of decisions that were made in 2001 by a developer of a project who decided that he wanted to proceed to build a golf course. And in spite of being advised that it wasn't allowed on that property, he proceeded. This is not the fault of Calaveras County. Okay? It was clear from 2001. This was a business decision, a business risk. It didn't work out. The environmental cases are clear on that, and I cited them again when we first started the EIR on this issue. On the other project, when a developer undertakes to proceed without appropriate permits, he does so at his own financial risk. And this was a financial risk that didn't pay off, it didn't work, but it can't be done at the expense of Calaveras County and the citizens here. This is a policy decision. It's a decision based on what was in your actual ordinance as it exists today. Thank you.
Okay, you have 11 minutes.
I'll be shorter than that by far. In terms of the appeal that is before us, and with all due respect to the majority of speakers who came up here to speak, the majority, some on both sides, they didn't speak to the issue of the appeal. They talked about why they support the Nemis or why the golf course would be good. But the appeal issue, it's like you're being asked to determine whether someone is guilty or innocent, and somebody's talking about something completely off subject. Because the economic benefits of something, or whether or not someone likes the Nemi, is not what the appeal is about here today. So I go back to the appeal, and the points that in particular was, again, the clear language of the county definition from agritourism. Again, with all due respect to the attorney representing the Nemes, I was an English major, and I can tell you very clearly she misstates when she says that when it reads, for the purpose of enjoyment, education, or active involvement in the activities of the farm, ranch, or agricultural operation, that it somehow separates out that enjoyment can be related somehow to the golf course, but education or active involvement is relating directly to the activities of the farm, ranch, or agricultural operation. It says very clearly, the act of visiting an agricultural operation for the purpose of enjoyment, education, or active involvement in the activities of the farm, ranch, or agricultural operation. That is a very important point, because that's the little straw that they're trying to grab onto to try to somehow to come up with, well, we may have been told that it wasn't legal. We're still going to say it was legal. You've turned down our application. The EIR acknowledged there's many significant impacts that haven't been mitigated. There's all these plans and requirements that we were supposed to do. But she said, don't think about those things. Deal with what's here today, which is the agritourism. With all due respect, the agritourism, as your own staff report has pointed out, is not the win for them. Instead, I listed before that it cannot be defined as agritourism for the reasons that your staff has put forward. I won't repeat them again today. The other key piece of information with all of this is the other connected appeals tied to whether or not you can consider it just landscaping. And again, as I pointed out previously, even the Nemes in their testimony before planning commissioners and before the full board over at the other main hearing chamber referred to it as the golf course. They didn't say our landscaping. They referred to it as a golf course. And they've continued to actively use it as a golf course. The last thing that I would come forward with as you consider what your action is going to be is, most of you are trying to find a way to make it work for the Nemes. About 4 years or 3 years ago when we were here, I had made some suggestion about if there's some way that they could have less than a 9-hole golf course or whatever, there's some way that it could work out. Wouldn't it be great that we could still give them something that gives value to the property more than having everything removed, and find a way that can make it work? And our center was trying to talk about compromise. But the Nemes have pushed forward all the way with not just their golf course, but an application to do all these other things at the time. And now they've continued for months to continue to do the golfing, even after the decision that the golf course was not allowed and was not given approval. So my perspective is you have a challenge, because one of those challenges is if you allow something to go forward with some sort of consideration that it will be limited, for instance, like that it may not be the tremendous amount of activity that was talked about in the EIR as creating so many tens of thousands of visitors and huge things on the weekends and all the other stuff. If you allow something to go forward in your best interest, trying to please the Nemes and keep them out of bankruptcy, the reality is that you can't control what happens out there. You can't have a bouncer there to find out, are they using it for personal use? Are they using it for commercial use? Or if it's agritourism and you're going to somehow challenge that there's going to be a court decision with probably consequences for taxpayers here, if you end up moving forward with something that your own staff has laid out the legal arguments for our side, for Kirk, for others of concern, if you proceed forward with that, you're doing what to me is the biggest issue that was raised at the Board of Supervisors hearings on the project, which is, will Calaveras County be the good old boys who find a way to let something happen? With all due respect, someone shared, well, look inside the box and don't really stick to exactly what's in there, but do what's good. Well, you have laws and regulations, and my hope is that you won't just try and interpret what might be good for the Nemes or good for the people that are supporting them, but you apply the law fairly and consistently based on your staff recommendations, and also recognizing that very clearly you've had a tremendous amount of information provided, that the NEMIs have not followed the directions that have been spelled out to them again and again. Thank you.
Thank you very much, Mr. Buckley. Okay, on the procedural side of this, we had the two other issues. Mr. Buckley, have you made all the comments that you, can you hear me, sir? Have you made all the comments that you wish to make on that, the appeal that you lodged about the landscaping issue?
The only thing that I would say on the landscaping is if Pebble Beach Golf Course is closed at night, it's still Pebble Beach Golf Course. Whether or not it's having golfers on it at that particular moment. If the Trinitas Golf Course has golfing halted for a period of time, it is still a golf course because it has fairways, tees, tee boxes, cart paths, all the other things that make it a golf course. And for the third appeal, I'll finish that one right now to make sure, is that the key point that I put forward related to the third appeal is that this county has the responsibility and the authority to either remove or to somehow deal with the golf course when it is being used for an illegal activity. Our center did not say that you had to have the golf course removed at this point. In fact, in the appeal position letter that I provided the Planning Commission, our center said, we defer to the fact that you guys may want to see this proceed through the courts and be resolved before you take some action, but that in the meantime, you have the authority and the responsibility to halt an illegal activity. That is what our appeal provided. The commission agreed with the landscaping, the same as with Kirk, but the commission didn't want to say that the county has the authority to stop an illegal activity, which dumbfounds me that the commission could possibly take that position. So our center argues that our appeal is clearly correct and valid, that the county does have the authority to actively halt an illegal activity that is taking place on the golf course, in this case, the continued commercial use of golfing. And I would also urge you to vote no on the recommendations that are tied to these appeals today, because there's no way that the county is able to enforce the difference between a personal use golf and a commercial golf, because you cannot screen all the people that would go in and out. Thank you. Good afternoon.
Okay, is there anyone wishing to make a comment about what Mr. Buckley has said about that regarding the potential removal of the golf course?
I just want to address that point real quickly. Chris Griffith, again, on behalf of the NEMIs. The issue that's presented to you today, like we said, is dealing specifically with these appeals. Even Mr. Buckley just said he's not asking you to order the golf course to be removed at this time. He's saying that to the extent that you find that your ordinance prohibits certain activities on the land that you have the right to enforce. And there's a subtle difference here, because actually what his appeal says is that you have the obligation to enforce. And what he's missing, what he's not telling you about, is something that we all are very familiar with, and I'll use the speeding example from earlier. The law enforcement does not have the obligation to stop every single person that's speeding, right? They have some level of discretion. And similarly, in enforcement of land use matters, the county has a level of discretion that can be applied to whether and how to enforce provisions of their ordinance. And given the circumstances here and the ambiguity, both in the, potential ambiguity in the definition, clearly, since we're all here today arguing about it, but also the pretty clear permission that they were given, at least at some level of county government, to put the course in the first place. I would encourage you to deny that appeal.
Mark Conley again on behalf of KIRC. Did you already take comments on appeal number 2? Because you indicated earlier you were just taking comments on appeal number 1, and then you were going to decide on appeals number 2 or 3, or am I incorrect?
Correct.
you're going to take testimony on all three and
Yes.
decide all three?
Yes, we are.
Okay, then I just have a couple comments on appeal number 2 and appeal number 3 to address the issues that were raised. On appeal number 2, I don't think there's any doubt that a golf course is a structure. We agree with your staff reports. A golf course is defined in your code, section 1746.020, describes your uses in physical terms of the land. As a matter of fact, it describes miniature golf courses and it describes driving ranges. A golf course is a golf course. Whether a golf course is 9 holes or whether a golf course is 18 holes, a golf course is a golf course. And to the extent that there's a suggestion that by reducing it from 18 holes to 9 holes that you resolve the problem, you do not. It is still not landscaping. It is a physical structure, as your staff indicates. That doesn't resolve the issue. On appeal number 3, there's a related issue that a golf course is obviously not agritourism, but our position is that in the original way that the resolutions were worded before the Planning Commission, there seemed to be a determination that you did not have, or the county did not have, the authority to take whatever action was necessary to either abate the golf course, to bring the golf course into compliance with its codes, to bring the NEMIs in compliance. That is why we appealed that decision. There's an issue that council's brought up as to whether the county has an obligation to bring the property into compliance with its zoning and its ordinances. Clearly, it is our position, KIRC's position, that the county does have that legal obligation to bring it into conformity with its own zoning ordinances. The suggestion by council that the county has the discretion to ignore a violation of its ordinances, to allow a golf course that's not allowed in agricultural property on agricultural property is not in conformity with the law as I provided in my brief. And not only that, such a position is not exactly a legally responsible position. I think all of you would agree that the voters of Calaveras County, the residents here, expect you to enforce the law equally. We had these discussions before. An illegal garage, an illegal structure should be treated no differently than an illegal golf course. There shouldn't be the discretion to ignore the law. But the third point that is, again, a subtle point, a slightly different one is what is the procedure that's going to be followed here to enforce the law? We agree that that authority is delegated to your staff and that they have to make the determination, enforcement, about how they're going to enforce the decision that you make. We're not indicating that you have to make an order today, since our position, to directing staff to take some particular action. But we believe that firmly, appeal number 1, a golf course is not agritourism. Appeal number 2, a golf course, 8 holes, 19 holes, is not landscaping. Appeal number 3, you clearly have the authority and the legal obligation to enforce the laws, regulations, and ordinances of Calaveras County, and staff needs to know it has the authority to proceed pursuant to the enforcement letter that was sent out originally and is the subject of all 3 appeals. Thank you.
Okay, if there are no other people wishing to comment on this, I will once again close the public hearing and bring it back to the board.
I'd like to take a 5-minute recess. I need to organize some thoughts, questions, if you don't mind. If you all don't mind.
Okay, we've had a request from Supervisor Callaway to take another 5-minute break. We had a postponed element of the agenda, that joint meeting. We're still going to try to do that this afternoon.
Off California, to the Gulf, Rocky Mountains.
Okay, if I could call the meeting back to order, please. Okay, just as a reminder, the public hearing is closed. We're taking this back to the board at this time. We will be actually discussing all 3 issues, one at a time in sequence. We may be asking questions of people that presented before, but we're not opening up the public hearing again. If the board wants to ask a question, we'll get the response, and then that'll be it. And then we'll hear, or make comments on all three issues, and then make, hopefully, motions and votes on the three issues in sequence. Is that understood? Okay. I'm going to open this up for board comments, questions. Supervisor Walensky, are you in the mood to jump into this?
No, not particularly.
Oh, okay.
Still writing my points off the notes. I would defer to
Okay.
the supervisor whose district this occurs in.
Well, I'm not at this point ready to make a statement on how I stand on it, but I because I'm involved in something here that I just got.
Yes. Actually, maybe it would make sense to take another 5 so we could complete the.
What did we just receive that I'm not aware of?
Oh, I think you had got it, but it wasn't attached to the packet for some reason. It
Well, I
either
thought we'd
fell
all
off
just
or
received something.
I never
else.
got it.
Where is it? So I can-
No, this is just the.
The document that was an attachment that somehow didn't get to me. So, however, if you want to continue to not delay it, I mean, Marita has a bunch of questions, I think, and then Steve has some questions.
God, you guys are chicken. I'll start out. I'll just do, who am I addressing? Where's Mr. White? Mr. White, please. Thank you. If an EIR becomes required, I mean, if one of the recommendations of staff was to prepare zoning amendments to A1, A2 zoning districts, I mean, if that's a path we choose to go down, there is an existing EIR on the project, and it then becomes, let's say, conditional use versus a permitted use, and then we'll require an EIR. Some of it seems redundant. Can that original one be used in any way?
Some of the material may be useful. All I can say is that it's not a foregone conclusion that an EIR would be required. I think the comment had to do with reviewing the project, whatever that ends up being, if it's a code amendment, for example, to review it under the applicable provisions of CEQA. It may not result in an EIR. It depends on the nature of the code change. As you said, in our recommendations, we were suggesting perhaps considering golf as a conditional use. And if that was the case, then it's possible maybe an EIR wouldn't be the resulting appropriate environmental document. That's something we'd have to deal with as we process that zoning amendment.
I guess I would like the board to take up item C about, at least we need to address that before this day's over. If we decide to amend AP A1 zoning districts, where does that leave the golf course?
Well, that probably depends on what you do with
A.
With A, I would say,
Okay,
yes.
well, I mean, I'm just sort of, these are kind of generic thoughts, and listening to Mr. Buckley's comments, if this goes further, for example, we've been told 2 or 3 times today, the water issue being possibly adjudicated by the State Water Board. Again, what does that do with the project? Every time we seem to go down a path, there's another pothole here. And so we need, it's not as if, I mean, my feeling is today's not the end of the story.
Mm-hmm. Well, I think that's true, regardless of what happens here today. That's correct. Again, it's hard to understand or even give you advice on the consequences until I kind of you have a feeling for where the board's going on probably the main topic, which is the first appeal.
Okay. And I know I asked you this, we discussed it yesterday, but I guess I need you to remind me. Item B, defining golf course, driving range, 9 holes less whatever, on zoning amendments. Is that going to be, are we talking specifically A1, AP, or are we talking about just definitions in 1706?
No, I think it's a definitional question. In other words, if we endeavor to define maybe for the first time what a golf course is and what a golf course is not, it would apply wherever golf courses are allowed. And they are allowed in other sections, in other zoning districts.
So, but it could be different for each zoning district. You could have an R1 master plan community and an 18-hole golf course, and you could have a business park, which allows golf also, with a different definition.
Well, I hope we could come up with one definition of golf course if that turns out what we're talking about. But perhaps there's qualifiers within each zoning district that deals with how golf courses are allowed, whether they're permitted or conditionally permitted or under certain circumstances, certain scale, certain intensity, that sort of thing.
Thank you.
I have
Go ahead.
a couple of questions. George, I'm looking at the alternatives listed by staff, and there's an A and a B. Can you explain B to me? Because I've been told several times several different things.
What B says is grant the NEMI appeal and determine golfing, golf courses, and golf-related facilities to be agritourism subject to a conditional use permit under county code. And again, this is not the staff recommendation. This is an alternative that we wrote here as a possibility. I think if you wanted to go in this direction, it would be our preferred way to do this would be to also amend the code at the same time, simultaneously, rather than...
Simultaneously with...
Well, if you determined that it was appropriate for golf to be a conditionally permitted use in either AP or A1, it would mean then that anybody who wanted to construct or develop a golf course would have to get a conditional use permit to do so. Right now, that code language does not exist in the code. And I think it's safer, and there have been a lot of discussion today about CEQA implications and other things about the decision you make. I think the safest way is to amend the code, to cover the eventualities. And in this case, change the code to make the provision for golf courses, however you want that to be, give us that direction, and then whoever wanted to take advantage of those regulations could do so either afterwards or simultaneous with that code amendment. That would be our recommendation, if that was the direction you wanted to go in.
And so when Marita asked a question about a secret review and being able to use the one that's existing for this project, that covered this project.
Right, I think where that would come into play eventually, and again, it's hard to say what will really happen here, but if golf became a conditionally permitted use and the NEMIs were in a position to apply for a conditional use permit in the future, I think some of that CEQA evaluation, some of the work that was done for that EIR could be used because it is specific to this site.
That's the only question I hear.
Supervisor Walensky?
I have a simple question, but I think it's illustrative of a point I wish to make later. How many pages are now in the record on this project, the overall, since the beginning?
Boy, I can't say for sure, but I do know that when County Council compiled the public record for one of for the litigation that was ongoing, I think it was around 11,000 pages, if I'm not mistaken. And there may be more than that, not contained in that.
Yes, we had more come in today.
Exactly, right.
Thanks.
I have another question. I'm reading under our ag code, under 17.06.0070.
This is in the A1 district?
Yeah.
Uh-huh. Hey, could you give me that site again?
Well, it's X'd out, but it's under the heading of 17.06.0070.
This is the amended version that was in the packet?
Yes, the amended versions, yes.
Okay, I'll have to find that.
Okay, as of October 3rd, 2005. And then it goes under agricultural operation. That's going to be under that heading is my specific question. And it talks about management practices. It says these techniques include, but are not limited to, brush removal, tree thinning, controlled burns, reseeding, pond and spring development, application of herbicides, and fencing. The cultivation and tillage of soil, irrigation, pruning, protection against frost, control of bird or animal damage, lawful and proper use of agricultural chemicals, pesticides, and fertilizers. So those are permitted uses, something that you are permitted to do under either AP or A1 zoning
That's part of an agricultural operation.
as part of an
I mean, this is a
agricultural
definition.
operation.
This is a definition that you're reading, essentially.
Correct.
Yeah.
So what it's saying is, if I had trees and I decided that I didn't like the trees as interfering with something I wanted to do on my property, like it was interfering with me seeding wheat or what have you, then I could basically remove those trees without a permit.
Yes.
Pond and spring development. I could actually dig a pond and develop a spring and ponds. It doesn't limit the size of those ponds.
This certainly doesn't. I mean, there may be other, state and federal regulations, ultimately we have to deal with.
This ordinance
But
itself,
this
I mean, you have to
definition-
check with other.
Right,
Yeah.
right, but this definition does not.
But our definition here says
Right.
those are permitted uses.
Well, again, this is a definition. It's not under the permitted use section. It's just a definition of what an agricultural operation is. So.
Okay, thank you.
Supervisor Callaway, do you have further questions? Supervisor Tryon?
No, but I'll sort of give you my opinion if you'd like it. So I went first last time, so I think someone else should go first this time. But if you're looking to me, then I'll go.
I'd say
Well,
seniority kids.
Unless you want more discussion.
No, I'm not quite ready to express opinions yet. I have a number of questions here of my own. But I want to defer to my colleagues here. No?
I think it's yours.
All right. We've been reminded repeatedly by learned counsel and learned citizens here that our responsibility here is to look at our existing codes and see if we can find an opportunity to grant this appeal or not grant it. There's been numerous references to that we should stick to the staff report because the staff report is somehow the suggestion that it's completely accurate and valid. I frankly have some problems with the assumptions in the staff report. Are there any members of the Ag Coalition here? Okay, we have one. You don't count. What I'd like to explain to you is that I have long been troubled by this the position. It's kind of like it's become a religious position of sorts that in this county we can only do. It's been referred to as the Selman rule, that you can only do, it's a permissive code, that you only do what it says you can do. And I was bothered by that. I have been for a long, long time. I specifically went to, on two separate occasions, to the members of the Ag Coalition, and I asked them for some clarification of what their role was in formulating the 2005 revision of the Ag ordinance. because it had always been referred by others, by Mr. Solomon and some of his people that followed him, that by golly, the people in the Ag Coalition definitely took on this issue, and they said that no way, no how do we want to have golf be a component of the agritourism component in this ag element. And I just asked them, did you say that? And their response was, let me read this to you. This is an Agriculture Coalition statements regarding uses in agricultural lands. This is a response that was given to me dated August 12th, 2009. The Ag Coalition did in fact participate in drafting the various ag land use ordinances enacted by the Board of Supervisors a few years ago. The precise wording of the ordinances in some cases represented compromises reached after discussions with the Planning Department and hearings before the Board of Supervisors. Overall, the Ag Coalition favored broad wording of the various ordinance provisions, as it was difficult to anticipate what the future will bring in Calaveras County. Getting back to what Mr. Rusk said a few moments ago, the wording of the ordinance speak for themselves. The wording of the ordinances speak for themselves. I'll repeat that. The omission of specific examples of uses should not be interpreted as evidence of the Ag Coalition's intent. For example, there is no specific mention of wildflower collecting being a permitted or conditional use, although we certainly assume that there is not a problem. Also, there is no specific mention of air bombing practice ranges being permitted or conditional uses. We certainly assume that would present a major problem. The Ag Coalition is ready and willing to work with county staff to address these specific portions of the agricultural zoning code that require additional clarification. Okay, so my dilemma is reading in the staff report where it says fairly conclusively that it was the Ag Coalition's position that golf would not be included as a permitted use in the A1 zone. Okay, another thing that has been particularly problematic, and as I've been viewing this, is the continuous references to things that aren't permitted in AP. As a part of the evidence that we've been given, this very lengthy staff report, there is a transcript of a portion of a Planning Commission meeting that took place back in October of 2007, where these parcels were intended to be reviewed by the in this particular case, it was the Planning Commission's sitting as the committee that reviews these non-renewal contracts. And it has long been the practice, and it says emphatically in this document here that when a parcel goes out of contract, it automatically reverts to A1. It's no longer AP. Now, Mr. White, could you come up and maybe weigh in on that? Because it is, again, I want to express my kind of anxiety about throughout the staff report, it makes references to things that shouldn't be happening on AP zoned property. Now, I realize fully that these two parcels in question here are currently technically zoned AP. However, back in 2007, I mean, two years ago, almost to the day, I guess it is to the day, it's a 6 today, but nonetheless, these parcels, the transcribed testimony here by Robert Sullivan says, oh yeah, that we do see that there is a glitch in the agenda, that we don't have the proper nomenclature in the staff report, so we'll pull these two properties off and we'll put them back on in 2 weeks. Well, it's been far more than 2 weeks since then. Now, I understand a lot of things have happened, but my firm belief is that if these items hadn't been pulled off by someone who is in this room, that they would be zoned A1, and all of the references here to inappropriate uses on AP they wouldn't have the opportunity to have that toehold of thrusting that up into to our faces that, oh my goodness, we're doing something wrong. So answer this question specifically. Are these properties AP by some quirkiness that took place after this hearing?
Well, again, I can't vouch for what happened at that hearing because I wasn't here, obviously.
Okay.
But I can say that the properties are zoned AP until there's rezoned to something else. And what is expected when a property falls out of the Williamson Act is that there will be a rezoning process, a legislative action that ultimately ends up here at the board, and those properties go from AP to A1. And that's happened on a regular course. As you say, in this case, events may have overtaken that process, and it did not occur.
Okay, but the point that I'm trying to make here, and maybe I'm not doing it adequately, is that the interim planning director at that time said it is the responsibility of the county to take these properties from AP and rezone them to A1.
That's correct. Yes.
Okay. Now, it's been suggested repeatedly by opponents of this project that somehow that this is the fault of the Nemes, that this parcel is still AP, and by golly, it's AP. They shouldn't be doing these things, but I don't know. I don't want to belabor this issue overly, but that is very problematic to me. That concludes my comments on that. I want to also touch on the fact that there was criticism about the fact that there was a representative of a financial institution here. I personally have no reluctance to take his testimony. I think it brings into focus the seriousness of this, and for any member of this board or public who might think that there is some sort of a sham or subterfuge going on regarding that particular issue. I appreciated the straightforward and truthful comments made by the banker. Hated to hear it, but I appreciate your comments. Okay, on the economic aspects of this, I also want to bring up, I think Chris called it a tome. I like that word, that this is a document that was prepared by our legal staff that reviews what other counties in the state do in regard to how they approach the particular issue of having whether golf is a permitted use in the ag zones. Now, the summary of this document, the way that I summarized it is that out of 55 counties that were questioned, and of course we have 58 counties, we wouldn't have questioned ourselves, of course, but so out of the 55 counties, 41 responded that yes, they would permit what we're being asked to consider here today. There were 10 counties that said no, that they do not allow golfing in the ag zone. Three counties said maybe. So what I'm kind of interpreting from this is that 76% of incidentally, there was one county that did not respond, so there were 54 respondents. 72% of those 54 respondents said that yes, that they would allow this to happen. So I'm wondering in my own mind, if I look back at the staff report that says our recommendation is based upon the fact that the Ag Coalition didn't want this, and then I have another document that comes from the Ag Coalition saying we think it's fine, we think that it might be beneficial for this county to look at economic opportunities, then I am thinking that maybe this county would be well advised to go along with 76% of counties in the state that do allow this type of thing. Less than 20% of them said that they would not allow it, and I'm not sure why that this county should continue to swim against the tide. That concludes my comments at this time.
I guess I'll chime in here. I spent a lot of time on this, as Janice and Jim know. I spent... I'm sorry? I spent a lot of time on this, as Janice and Jim both know. I spent a lot of time in their office. I spent a tremendous amount of hours on my own, all last week, once we got the package, over the weekend. Even this morning, before I came in early and was on it, trying to take in all of it, understand everything that was going to be spoke about today here, and also all the implications that could happen after we leave here today, depending on what the outcome of this is. I guess part of the problem that I'm searching for is the designation between A1 and AP. There's very, very little between the designations, and they both have agritourism listed in them. And generally, AP in our county is usually under Williamson Act. And like it's been testified here before, earlier, that it's usually rezoned to A1 afterwards, after it comes out of that contract. But yet, again, after searching this thing, trying to find a way, the designations that are in our codes as far as agritourism appearing equally and mutually in both zones is just something to be reckoned with me. I just struggled with it. The intent of it, the intent of what was written, the intent whether Goff was supposed to be in it or not, the reasons why it wasn't, what's a permitted use, what's a conditional use permit for certain things. And this decision today is not primarily on NIMI's or Trinitas project. This is an interpretation of what we're allowed in our codes in these two zones. And the way it stands right now, without having staff going back and making some recommendations to us on designations in these two zones, including Goff, it really throws a lot of things up in the air, in my mind. And I really struggled with this on how I could find a way. I've asked thousands of questions, and I appreciate Janice answering what probably were some stupid questions, but I wanted to get it clear in my mind, and I probably spent all of my minutes on my plan on the phone to the county counsel's office. And I'm open to having staff come back with some recommendations to us for an A1 zoning that would include Goff in it. I can't clearly agree with anything that would be in an AP zone simply because state laws say, the DOC says that Goff is not an acceptable designation or use for that land under Williamson Act. But I think if we have some recommendations to us about changing some of the A1 zones, some of the codes in the A1 zone and what's permitted and what's a conditional use permit, then we will have some leeway into saying that Goff is a permitted or a conditional use permit in an A1 zone. And I would think that I would probably make that motion here today, asking for that to happen, and probably look at a lot of different distinctions that we could put into that between the AP and the A1 codes, so they are distinct in their own self, and it's very clear that they are two separate things. I don't know where the rest of the board stands on it, but that's how I feel at this time.
So where are you on the appeal?
We're just doing Appeal 1 right now, correct?
Yeah.
Well, I asked about option B, and I think I'm in favor of something along the lines of what option B has to say here. I truly believe that it should have a conditional use permit applied to any golfing or any commercial use golf course in an A1 or an ag zone. So I might try and amend this when I make a motion, but I think along the lines.
No, you can, you have to check with council, but I'm not sure you can amend an appeal. It's coming.
No, I mean the alternative.
Yeah, well, that's to staff to bring something back. That's different than the appeal. You can't amend the appeal. Correct me if I'm in error, Jim, but
I think that's right.
you can't amend.
I can't amend the appeal, but a motion that I can make
Yeah, you
can be based upon this option B. Is that correct, Jim?
I believe so, yeah.
Well, you can direct, option B would direct staff to bring back something for the board to consider.
Correct.
Yeah.
Did you want to make your summarizing comments on this first issue, Tom?
Okay, I'll give my comments then. Let me start by saying that I don't believe an 18-hole golf course is agritourism. I think that's a stretch considerably too far. Having said that, let me go back to sort of where we started on this. And I voted against the initial proposal because I felt it was lacking on infrastructure, being that it wasn't on public water, surface appropriated water, it wasn't on septic, it wasn't on acceptable roads, and it didn't have a, in my opinion, location that gave it a close proximity to a community center. And I look at where we are now, and you know, and those reservations I still possess. If this had come under the agritourism for a commercial golf course, I don't believe I would have supported the agritourism ordinance. I think we do have an obligation of trust and duty to the citizens, in my opinion, to, for lack of a better term, protect and promote agricultural activity in the county. We basically agreed to continue funding applications for the Williamson Act, and have not heard, or at least I have not heard any opposition to supporting agriculture in that way. But I think we start to violate the trust if we just sort of turn agriculture and agricultural zoning into activities that the general public and both myself would view as being, you know, fairly considerably divorced from agricultural activity itself. If we were to consider a golf course to be acceptable in the A1 zone, I think it would definitely need to have a conditional use permit. I don't think you can just permit it as a ministerial act, because if you did that, there would be no mitigations, there'd be no road improvements, there'd be no infrastructure improvements, et cetera, and I don't see how you can open an 18-hole commercial golf course and say we are not even going to consider infrastructure improvements. So I think it would have to be a conditional use permit, and quite frankly, if it were, the things I would be looking at would be the four things I just stated that I didn't support the original application. One of the problems we have here is that this is all after the fact. I mean, you could have pulled Calaveras County's planning department and say, do we allow golf in A1? And the answer would be, or could be, yes. I mean, if you come in and get a specific plan, which does require a general plan amendment in the A1 zoning, you could, with the appropriate approvals and consistent with state law and county code, et cetera, you could put in a golf course in A1. If we put it in under a conditional use permit, then you can put in a golf course, but I guess the question will be, what are the conditions? Obviously, a conditional use permit requires an environmental review. A permitted use does not necessarily do so, being a ministerial act. So my inclination is to uphold the Planning Commission's decision on the agritourism appeal. I am not going to vote to grant the appeal. Let me just make two other statements. Number one is we're here, in my opinion, basically for two reasons. Number one is the applicant did not get the proper approvals prior to the project, and there's much in the public record showing, quite frankly, a misrepresentation of intent. And secondly, I want to, I guess, take exception with the bank representative that's here today, because that's the second reason we're here, is the bank didn't do their job and basically made a loan of several millions of dollars without entitlements, having been granted by the county, and I take grave exception to the bank having made what I would call a very negligent loan, and we saw that all through the housing crisis that we're now experiencing, where the bank makes the dang loan and then stands up before this board and says, well, we're going to foreclose on our loan, bank, and this board takes a particular action. I think that's entirely inappropriate, and if the bank had done their job, I'm not sure we'd be here today either, because the loan would not have been made, the improvements would not have been done, and it's due to the gross negligence in the management of the structure of the bank, at least as concerns this loan, that has also brought us here today. So that concludes my comments on the first appeal.
Supervisor Walensky.
I'd like to begin my remarks by thanking the people who have stayed through this entire hearing and through these even 8 years. Your tenacity amazes, and while it makes our jobs more difficult to have this level of public participation, it certainly expresses a lively democracy in Calaveras County. How we practice it may have a few things to improve, and I'd like to talk about that in a few minutes. But I'm writing a book called You Know You're in Trouble When, and I have a new entry today. You know you're in trouble when you're discussing an ag issue and there are more lawyers and bankers in the room than farmers. So with that, I'd like to take you through my thought process on this. It starts quite a while ago, back in 2002, actually, for me, working with Calaveras Grown. The ag community was in pieces. We had small farmers in Calaveras Grown. We had big ranchers in the Cattlemen's Association. We had the wine grape growers and the vintners not necessarily working together. We had a lot of pieces of it, and we spent a lot of time arguing whether goats were actually fair-worthy animals or just cattle. Flash forward a little bit, and you see an ag community recognizing that the rate that we're paving the best ag land in the world down in the valley, and the elimination of a good portion of the agricultural production capacity of the United States is actually something that should concern all of us. And it began concerning the ag community enough to actually begin meeting together and thinking about what we would do here in Calaveras to buck the trend, to at least slow the liquidation of ag lands. And that led to a reform effort, a revision of our ag code by people who were learning about code, were putting things together, a volunteer group that worked its butt off to bring forward what now appears to be a slightly flawed, but nevertheless significant progress, in my view, document. The process was actually quite thorough. It was vetted quite thoroughly, and at least one part of this included proposals within second or third final draft that included golf. The final one did not, and there's a lot of discussion about how that occurred. But to my way of thinking, whatever iterations will prevail are going to be likely heard in court, and you'll probably get more than one opinion, because the truth of the matter is that the community that was discussing it did not have either strategic or content unanimity. There really were differences in the room. Some thought that putting golf in was a bridge too far and would not stand. Some felt that it was an important piece of what could become an agricultural, an economic boon to agriculture. And that was actually the main purpose of this, was how do we keep ag land in ag production? What are the things that we can do to improve the prospects for hard-pressed farms in Calaveras County? In the end, the decision was made to take the word golf out of the ag zoning code proposal that was passed by the board. Ag still finds itself, not ag, golf still finds itself in the recreation zoning, and that's something I'll get back to later. One thing that really worries me about what we've been through together in all of this discussion is that the dark words of Supervisor Callaway at the time the ag zoning code came before the board was, if this gets out of hand, if this becomes a stalking horse for non-ag activities, or it moves way beyond the original intent, that this will ultimately come to discredit the ag community, and that we will be wind up trying to defend the last remnants of an initiative that was designed to actually help ag. We will have created a level of numeric opposition to these kinds of reforms that will ultimately be our undoing. Personally, I always hate admitting that another supervisor in opposition to something I was supporting might have had a point, but in this case it appears that we may have gotten very close to that. Something I wanted to talk about also that I think is when we divide ourselves up this way, some unfortunate things happen. But what I want to put on the record here today is that the work that the staff did, imagine if your job, after having a good portion of the people next to you laid off, is to somehow sort through 11,000 plus pages of input, thank you all very much, and try to make some order of it, try to put it together in a way that makes sense, not just for the project as a whole, but individual appeals such as what's before us today. Each one requires a complete reconfiguration and a different focus. Not that we ourselves have been focused today, because the issue before us, as even the attorneys at least stated, and then probably contradicted, is only the interpretation of our ordinance, our code. But to say that the staff was derelict, or to imply that somehow the people who worked so hard and with due diligence on this effort, or to target people by implication in litigation who were doing their jobs with due diligence, has a chilling effect on the ability to do work with integrity. And I want to just personally thank the people who, with some degree of courage, put their nose to the grindstone. I don't know how many hours past what we pay you were worked, and there probably are all kinds of Fair Labor Standards Act violations that went with this, but you did, from our first planner who went out and suggested that there was a problem perhaps and that people ought to look at it, back in 2001, I believe it was said, to the folks who put this report document for this simple hearing and appeal today. I just want to thank you from the bottom of my heart, and while I don't agree with everything that's in it, your work does speak for itself, and certainly the effort shines. By the way, I think this is one of the best staff reports we've ever received in terms of its organization and its detail. Now I'll tell you what I really think about some other things. One is that the idea that we are now 2 hours into, 2.5 hours maybe, into a hearing on housing, or that we have not completed our general plan, or that we have at least 11 community plans that I know of that have not been thoroughly reviewed, or that we have 7 or 8 ordinances that are in draft form that have not yet come before this board, and that this kind of work could have been devoted to that, makes me wonder how we managed to spend our last 8-9 years in a world of golf while these other things went unaddressed or with a lower level of attention and detail. My personal preference would be that this caliber work would be devoted to the things that I believe I was elected to try to work on. Now, as to how we deal with one another and how we get to moments like this, it has a lot to do with strategies and tactics. It has to do with the kind of behaviors that we exhibit when we have disagreements. There's certainly no unanimity in Calaveras County about virtually anything, but how we handle our differences matters a lot. It has something to do with how we go on after disagreements. It has to do with the kind of communities and the fabric that we tie one another up with, the ability to get things done in other moments, in other days, in other arenas, on other issues. It has a lot to do with how we process things. So here we are with, 2, 3, 4, 10 lawsuits, with a great deal of our time and attention devoted to something that actually, in my district, we're the only district without a golf course. And I'm just not sure a whole lot of my constituents really regret that a whole lot after this experience. But I will tell you that it is not the biggest thing going in District 2. The biggest thing going in District 2, when I go up there, people are talking about how come we're raising garbage fees because we're broke already, or how come we don't have a house, we're living in a tent out in the forest. How come it's so hard to get anything done just in a simple day-to-day way in this county. And I can tell you that the distraction and the amount of time and energy after having gone down this long and winding and twisted and unfortunate road is something that I hope we will learn from so that we do not repeat this type of work. But I'll tell you, we have divided even our media's family on this. and you have a divided Board of Supervisors, you have a divided Planning Commission, you have a divided communities, you have a neighborhood torn to shreds, that speaks more of the tactics and strategies that people employed early on in something that should have been mediated 4 years ago, that should have been worked out. Neighbors talking across fences can usually get things done in this county, but instead, we lawyered up fast, we got into disputes, we blamed people, there were vilification of individuals, there were kind of attacks on people on both sides. I can see the pain in the people's eyes when they spoke to us from the neighborhood, from people who take different positions on the issue, from the people who originally wanted to make a golf course. Regrettably, during the course of it, it wasn't just a golf course. It was a vineyard. It was landscaping. It was many other things. So when you ask, where was the county? People said, okay, where were you? Well, I'll just read one little paragraph. It says, there were statements, and by the way, read the 11,000 pages because you'll find these statements in writing, in the record. But there were statements that included that the land was being prepared for grazing, landscaping, installation of a vineyard, and then in response to questions about a golf course from code compliance, as a few personal holes of golf. Now, I understand that projects evolve and that we figure things out and we get resources or we don't have resources and things change. But when people blame the county and its staff for not keeping up with it quite right, you have to look at what was in front of them at each individual time along the way to be able to figure out what they were actually responding to. And then if you mix and match the responses, you can say, well, yeah, you agreed with a personal golf course, 6 holes, and an agritourism center for sale of local produce. Well, that's not necessarily an agreement for the concurrently advertised 18-hole world-class arrangement. So, yeah, the county may have shown different looks at different times in relation to different bits of information and presentations that came before it. We wouldn't get into this level of dust-up with one another if we were all dealing with the same fact base. So I suggest to everybody in this room and anybody who might be listening that maybe we ought to do some remedial education. Take those 11,000 pages. You want to really know what's going on? And there's a lot of stuff that's been spoken here that actually conflicts with the history that's pretty darn clear in those documents. And I would very strongly suggest that if you have any doubts about whatever this board decides, if you have any doubts about whether there is a basis for a decision that is made, you should read those 11,000 pages, as you have forced us to do ourselves. This has been arduous, but it does lead me to the last point I want to make. When you're interpreting, now I'm not talking about anything, I should say one last thing about the politics of division. It's not just about personal politics, it's about histrionics, exaggeration, and hyperbole. So, for instance, on both sides of this issue, I've been fascinated to listen to the water stuff. My well's going dry. Yeah, well, guess what? There's wells going dry all over Calaveras County. There's wells going dry all over that basin at its top edge because it's going down at 1 foot a year and has been doing that for 40 years. Here's what we know about it, that it's going down at that rate. Here's what we don't know. What's the effect of a golf course or any other ag activity or other non-ag activity or ag activity in that particular part of the basin? Is it on the edge of something? Which side of it is on? Which of these parcels? You could be living right next to it on one side and have no effect, maybe have a big effect just right adjacent to it because of the nature of the underlying geology. What was told to us and what I believe, and I'm really saying a pox on all of the people who spoke on water, is that we don't know enough, that it would take 5 years of hard study to actually have a clear picture, and that the only thing that we do know is that we would be able to have adequate water if we managed to get surface water down there. And despite the generous offers of participation in helping to bring surface water down there by the applicant, it falls many millions of dollars short of actually being able to get it done. And that's going to take more time than probably we have in relation to this project. So when we exaggerate to make a point, we deepen the conflicts and we abandon fact for speculation, and then we lose a sense of trust. And that's happened in this neighborhood in a way that I can only hope you'll figure out a way to heal, but it's going to take as much effort as you got going into this to get back on a neighborly track. Now, as regards the issue before us today, there are several things that are important. In the interpretation of an ordinance, there are three different levels of review. The first is, what was the intent, if it's clear in the language? Now, even the lawyers today, or at least one of them, has suggested that, well, we don't seem to have full agreement on that. So if the intent is not entirely clear, you look at the legislative history, you look at what happened in the discussions leading up to it, what was the intent of the whole board in approving that language. And then finally, if that intent is not clear, you would move to a last criteria. And I'd like to read you some aspect of that because I think it might defy the laws of physics to accomplish, but I think it's really the matter that's truly before us here. If you can't get the legislative history clear, if you can't get the intent from the language, then you should apply reason, practicality, and common sense to the language. You should avoid an absurd result. You should also consider it in context with other provisions of the code, and it must be harmonized. The decision must be harmonized with other ordinances by considering the particular phrase, clause, or section in the context of the statutory framework as a whole. And so I'm trying to figure out what's reasonable. I've heard a whole lot of people talk about, and quote, from San Diego, the ag commissioners, or the UC extension, I should say, farm advisor, with their definition of agritourism. You've heard the Calaveras version and what's in our code, and you've heard the UC Davis extension. All of this is in the record, and there are subtle differences. But in order to find out what's really going on out there, and I'm very pleased that we received this document, there are over 600, and this is from the UC Extension's list, University of California Small Farm Center Agritourism Database. And this has over 600 entries from every single county in California, not one of which, despite all different interpretations of golf, has listed a golfing activity.
There was one.
Maybe one? I missed
Solvang.
Solvang. Excuse me. I missed Solvang. All right. There's only one county in California that has golf as a permitted use, and that's Riverside. And Riverside, actually, I thought actually was a golf club. So the question, I've actually been there, and there's a lot of golf going on, that's for sure. But anyway, looking at what's reasonable, looking at what's going on with all these interpretations, taking a look at where in our zoning code, regardless of what the ambiguous history or the differences of opinion from those in the room, we have golf in the recreation zone. We do not have golf in the ag. In my view, the big challenge here is whether we will have the rule of law, whether we will apply it equally to all, regardless of privilege, rank, or resource, whether we will have some integrity to our codes, however in need of revision some might be. It's important that we at least do not twist our own laws to fit a particular circumstance. Flexibility is one thing, but complete self-contradiction is another. So I will vote to deny this appeal on the first issue.
Supervisor Callaway, do you have any additional comments on this?
Yes, I think Steve was right when he said there was no trust in the neighborhood. There's also no trust in the county as a community on this issue. Mr. Hamilton said this has torn the community apart and that this has been the most difficult and painful issue in the county. And since I've been on the board, I can probably attest that I think that's true. What I've heard today is that the chamber wants flexibility. A constituent called me Sunday night and said because times are tough, he thinks, we should waive the requirements in our zoning code. And I said, but what about when times are good? He said, well, then you follow what the code is. Bob Mulvaney wants clear rules. Les Martin wants to change the definition of ag tourism. Mark Conley wants us to enforce the law equally. Mr. Buckley said if the county goes forward, there's no way to control it. And Ms. Griffith said, what was the intent? The existing course qualifies as ag tourism. A1, AP should be open-ended. Russ Thomas talked about what the Ag Coalition wrote, that they favor broad wording. Well, broad wording gets us 8 years later to where we are today, and there is no end in sight. The Ag Coalition had stated, it's difficult to anticipate the future. They are correct. And when the future comes and we need to modify things, we will do it at that time. When things are so broad, it is totally open to interpretation. And I'm not sure that applications can be applied when everything is so open to interpretation. I believe somebody addressed that earlier today. The ag community, when it came to us in 2005, asked for changes to ag zoning, that ag tourism be there so they can preserve the ag industry as a viable economic activity in Calaveras County. And they wanted ag tourism in to supplement agriculture and to help the owners stay in agriculture. It was a very controversial issue for me because one of the conditions that they wanted were events. And for those of you that were here then, you will know I had voted against the changes because of that, because of the events. And I've maybe since moved on. But what is Calaveras County? We say we're a right to farm. We say we're an ag county. What are the cultures and values of the community? I've been to the community planning meetings that we had in different parts of the county, and generally it's we want rural, we want open space, we want agriculture, and we need to be concerned about the intensity of use. Now, there is a schism going on between growth and open space and agriculture. And that's something that we need to work on as we move forward, and the general plan will be part of that process. I'm not averse to where Gary Tuffanelli might like to go, but at this point I do not consider golf as agritourism as currently defined under whether it's A1 or AP. Now, the issue, so I will be upholding the Planning Commission's decision. I not clear, though, on what does that do for the applicant on the existing, on what's existing now. And I think, John Buckley kind of left the door open to consider options, and maybe there's a way we can come to some resolution on that, but that would be mediating between the parties, and we might be past that point now. So since Steve took a lot of the time,
It was getting a little hot over here. So.
yeah, I voiced my opinion on the issue. Thank you, Mr. Chairman.
Supervisor Toffenelli, you have any wrap-up comments?
Well, I can count 3 here. I would hope that when we speak of compromises, that the 5 of us could come to some type of compromise on this issue before us. Just open for discussion here. If there was some type of amendment to, I don't want to use the word amendment, but if there was a motion up here to have staff prepare something to come back to us that would amend the codes between A1 and AP, defining agritourism, distinctions, what's permitted and conditional permit between the two, that might include golfing in A1 as a conditional use. Would anybody be open to that?
I'll talk about it because I've given that a lot of thought. I'm open to the discussion. I don't know if we should be doing it piecemeal as zoning changes or wait until we do the general plan. I mean, I could argue both sides of that. I think the issue of golf is allowed in many of our zones, current zones. It's not in this one. I think the code's very clear on that, or as I interpret it. So, I mean, I'm open to it, but I think it's going to not be a short-term issue. I think it'll be extremely controversial, just listening to the comments that are here today, that we've had at Planning Commission, that we had in May when we dealt with the project being possibly rezoned to recreation. So to look for an easy fix, I don't think that's going to happen.
Well, I'm not talking about an easy fix, but if you also read the cover sheet to what was prepared to us that Steve spoke about, it says many counties include golf courses as a conditional use in agricultural zones.
I understand that. I'm not every county. I'm Calaveras.
Well, I understand that too, but we're all, many of us spoke here today and we talk about a compromise. And I'm open to a compromise. I think going at this open-mindedly, it should be what we as a compromise position, we should talk about here.
Well,
and I don't hear anybody else chiming in besides the 2 of us, but it has been discussed about all of this, about everybody, about we wish it could have been compromised. We wish the 2 parties could have got together. We wish that they would have been in the same room. We wish it would have been mediated, yet we're same 3-2 as we were on the issue before, and I don't see any compromise on our part.
well, the
I mean,
issue,
you want me to compromise and say, okay, I'm willing to concede, and I have. I've said that I don't think it should be a permitted use in AP, and I'll stick by that. I don't believe that's the way it should be. However, I am open to the fact that it could be in a conditional use in an A1 zone.
But I guess I have a question about procedure here. Before us is an appeal which we either uphold or deny. There's not I don't see this as something that is possible to do, and I'd ask County Council whether that we can proceed with Gary's initiative in this context.
Well, I think I would defer to Mr. White on the planning aspect. This whole issue is swirling with litigation and potential litigation, And if you want a discussion with us on that, I would strongly suggest that that be done in closed session. But I think that the question is whether there's a mechanical way that Mr. White can work on.
Yeah, I think what Gary is talking about is pursuant more to our recommendations B and C. I think it was our understanding that we would deal with A first, and then we go on to B and C, because I think regardless of the outcome, the code still is crying out for amendments to have better definitions, better clarity, deal with ambiguities related to agritourism, obviously. But again, I think that's secondary to the main issue, which is the appeals before you.
Then basically what you're saying is if we go with B, then it would say grant the NEMI's appeal, and then have you come back to us with recommendations.
Well, as I said before, I think our recommendation would be to essentially have you initiate that code amendment that would potentially make golf a conditional use at A1. That would be, I think, the safer route than just saying it's so. And again, it gets back to some, I think, the litigation issues that Jim was talking about.
Would that satisfy the appeal?
Well, again, all it would, in a sense, do is defer the decision to that point where a conditional use permit was possible. And I'm not sure that works for the NEMI's or anyone else at this point. That's a decision that you'll have to make. It's not our recommendation, obviously. Our recommendation is to deny the appeal. Yes.
Supervisor Toffenelli, when you're talking about the option B, are you talking about option
I think
alternative?
B.
Okay.
C.
Option B as listed on page 13?
It's on page 13 of
13.
But it says subject to a conditional use permit under county code.
I just,
Recommendation, what are you looking at?
I'm just gonna make a motion because we need to deal with one of the issues before us. But the applicant in 2006 wrote a letter, said it would be a violation if I would allow it to be used for golf course play for private or public tournaments or play. I have not, nor will I, until such time as the Planning Commission or Board of Supervisors take action on this proposal. So the applicant has said there will be no golf there until there's some kind of action, in essence, wanting the course. I move that the Board of Supervisors deny in their entirety all appeals to the Planning Commission of August 20.
All three?
Well, one is a denied, one is granted, and the third is denied. The
So
one
uphold
to
the position of
Planning
all three.
Planning Commission's decision.
On the front page, that's A.
Correct.
That's A on the front page. In other words,
That's
Marina's
me.
motion upholds the Planning Commission decisions,
Correct.
and all appeals of the Planning Commission decisions are denied.
Yeah.
That's your
And
motion.
then, and then we can go down the path to where Gary wants to go, but we have to deal with what is before us and what is before us.
We'll run that by me again. So you're upholding the Planning Commission,
Decision.
their decision on the three appeals?
Correct. Doesn't mean we can't go.
Which would deny the appeals before us now?
Yes, it would deny all three appeals, because they're all three of the Planning Commission decision.
And then, council, can we go down that path now?
I'm sorry?
Can we go down the path after this, as far as recommending the staff to come back to us?
Yes, you can do that.
Well, I think if you're talking about changing the zoning code, of course you can do that. It's the discussion I think we need to have reserved for later is how that would affect this particular project. Yeah.
I mean, that's going to, this way, if you change the A1 zone to make a conditional use permit for a golf course, that has to be standalone. You can't take that decision and tie it to a compromise for Trinitas. I mean, that has to stand on its own independent merits, absent anything to do with Trinitas.
Did you read B?
But I'm looking at the front page, and you're looking at a different
B,
page.
there is, I believe, and George, if maybe you can help us with this, but as I understand option B, it would be for us to direct staff to bring back to us at another date options.
I think that would be the safest
That's
course.
not something that we can act on today.
Right, in a sense, it requires a legislative action, which is the code change itself.
Right. So
That would be my recommendation. Again, I defer, Jim's legal view on that, but I think that's the safest approach.
There still is some confusion here. Supervisor Toffanelli is continuing to refer to option B on page 13. And I think that at least two supervisors at that end are looking at option B on page 1.
Yes, that's correct.
Page
Page
I think the
13.
difference is between our recommendations, the staff recommendation, and the alternatives that we had listed at the end, which is a number of things that we were not recommending.
Oh, I see, okay.
Subject to the conditions.
I see what you're saying.
What is he saying? I don't
No,
understand.
it's on page 13.
Yes.
So it would be the alternative to denying the...
But you can't grant it and determine that golf and golf courses and golfing-related facilities to be agritourism subject to a conditional use permit.
We're not
I mean, we
talking
can't
about
do
golf.
that right now.
Tom, we're not talking about golf-related facilities.
I'm just saying what
We're
B
talking
says.
about golfing
I'm just saying what
in-
B says. I mean, we can't insert a conditional use permit requirement at this time. I mean, that has to come back.
I would, based on what I'm reading here, I think that you're not citing a correct statement. This staff report gives a recommendation, and it also says that we have alternatives, one of which is B, that says that we could grant the NIMI appeal and determine golf courses, golf-related facilities to be agritourism, subject to a conditional use permit.
Oh, golf-related facilities.
But we have no conditional use permit in the code.
But I think the intent under that scenario was that that legislative change would actually take place through the proper process. Again, it's not articulated that way because we weren't recommending that particular alternative.
In this case, don't we have a procedural issue? We have a motion,
Yes, I'll second the motion.
and then the question is whether that stands. And in the alternative, if that does not, then we would move to consideration of an alternative.
Okay, we have a motion and a second on the question. I just want to make a couple of editorial comments here that we've had statements here on the board that they can't find the window of opportunity that we've heard people talk about within our existing ag zone. There's been a suggestion that in family holdings of 470 acres, devoting 80 acres of that total amount of land. I mean, there's been some suggestion that the golfing is the far and away the principal activity there. But as I look at this and look at the investment that's been made there, this is like a poster child for what the ag ordinance is asking our ag community to do, is to when the economic potential for that 470 acres as grazing land or as olives only doesn't afford an opportunity to make a living on that land, then we are giving an opportunity to supplement or augment the income stream. So I'm a little baffled about why we can't get there. But anyway, we have a motion and a second. All in favor for the motion say aye.
Aye.
All in opposition to the motion say no.
No.
No. Okay, the motion passes on a 3-2 margin that we are denying the NIMI's appeal and upholding the actions of the Planning Commission. Okay, now, I think there was a second part of that, a wish or expression of a desire to maybe modify or to at least initiate a modification of our zoning ordinance as it applies to A1 and/or AP.
I think we need to have a discussion on it. Are you open for a discussion, Tom, on that?
Yeah, I don't think it should be an AP. I think we should have a discussion of A1.
A1.
Yes. Because AP shouldn't exist unless you're in the Williamson Act. It should be going to A1, and we need to make sure that happens.
Exactly. It should go out to
Yes.
A1 in a relatively...
And then we should have a
some timeframe.
discussion, and I'm looking at page 1 here, and it basically says, staff recommends the Board of Supervisors direct staff to prepare recommendations for a zoning amendment, and I would say to the A1 zoning district designating golf courses and other unspecified agritourism uses as conditional uses in the A1 zoning district. I don't mind looking at that, but, looking at it means it's a long way from it. I think we'd have a very robust discussion of what those conditions should look like. And I guess the one thing I'm a little concerned about here is do we want agritourism right now? It's in the A1 district.
It's in both districts.
It's in both.
It's defined the same.
I think we should take everything out of AP, except the Williamson Act, and agritourism and everything should go into A1. So when you come out of the Williamson Act, you should automatically go to A1, and that's what the code calls for. So there shouldn't be other uses that are taking place in AP, in my opinion. So I think all of that needs to go to A1, and
So
I don't mind looking at that, and maybe like on agritourism, if it's under some scope or scale or size. I look at agritourism as being sort of small scale that sort of blends in with the agricultural
So in a sense, the
operations.
direction would be that AP would be limited to only those uses consistent with the Williamson Act contracts.
Yeah, that's what I think. I think AP should be limited to the Williamson Act contract.
I would agree with that, but I also think that the process of deliberation here needs to begin with a consult between the department and the Ag Coalition and begin to look at what we've learned from this and see whether we can repair not just one piece of it. I'd hate to see us talk about golf and then have the next discussion be a nuclear power plant.
Well, and if you noticed
Tennis
in the recommendation I made, it's also with these other unspecified uses, which I think is really a more troubling.
And I think identifying those unspecified uses and looking at what other counties have done about this, there are some very successful ag zoning ordinances that involve and define agritourism to a greater extent than we were able to. And I think now that we have, again, tomes of information on that alone, it would be good to have a discussion with the ag community, come up with some options, bring them back to the board.
I mean, we obviously don't have anything predetermined here. I mean, it's just a matter of getting some direction and then starting to work with the appropriate parties to draft that.
And you could even divide it into sort of 3 levels of intensity, one being an outright permitted use for agritourism, riding, hiking, hunting clubs, fishing clubs, those sort of things that are pretty straightforward. You could have one that's a little more intense, and that being an administrative use permit, and then have something like an 18-hole golf course or bigger things be a conditional use
Right,
permit.
and that construction already exists.
And an administrative use permit is appealable to the board also. So, I mean, if there's controversy, you can bring it to the board. You could try to kind of figure out, kind of what levels we're dealing with here. But an 18-hole golf course is pretty significant. It's going to bring in a lot of people.
Right.
I don't know how many 18-hole golf courses there are that have nothing but the golf course and a public restroom. I mean, usually it comes in and they want a clubhouse and they want a restaurant and they want the 19th hole bar and, they want to have some weddings and they want to do normal things that would be complementary to such an investment. so that they get a positive return. So, a lot of time we're talking here just golf course. Well, it's more than a golf course as far as greens, and we need to. And in here you say you need to define kind of what
a golf course is and what it isn't. Yes.
Yeah, and what is included.
Right.
In that. It's going to have to be physical structures.
Okay, Mr. White, I have a question for you. Looking specifically at that sentence that Supervisor Tryon just read about the staff recommends the Board of Supervisors direct staff to prepare these recommendations to the A1 zone. I mean, if we, I mean, I don't know, maybe this is too logical, but we've got this option ahead of us, or in front of us today. Can we not make that motion to give you that direction? And if so, how long would you predict that would take to bring that back?
Well, again, I wouldn't hazard, a guess at this point in time, given that this is going to be an iterative process. It's not going to be simple, probably, and it does require, I think, a public process with some intense public participation. I think I know where you were headed, which is, once that conditional use permit provision is there, the NEBIs can take advantage of that provision. I just, at this point in time, would not be prepared to give you a schedule for that happening.
Well, why not?
Because of many of the things that Supervisor Walensky talked about already. There are many things on the plate. Again, if this is going to take the highest priority, that's something I probably should know right now. If it's going to be in the mix with all of the other things that have, competing priorities, then, again, I could certainly come back to you with some sort of schedule, but I couldn't necessarily swear to that right now.
Okay, I understand. All right, well, we've talked about this to a small degree. Supervisor Tryon, do you have any inclination to make that in the form of a motion?
Well, I don't know that we need a motion just to give direction, but
I think the direction is fairly clear.
I want to just stick up for George here a little bit. I mean, the general plan's pretty darn important, in my opinion, to get that done. And you got 3 or 4 other things over there you're looking at, and you have a normal workload.
I would say we probably have an abnormal workload, actually. But
yes, okay. And quite frankly, if this discussion comes back based on Trinitas rather than just the merits of what we want to do, and we're looking at litigation and huge controversy and the like, it's like, why bring it back?
And that's not my intent, obviously. This is about appropriate uses in ag zone land.
In some environment that we can, have some consensus.
Right.
And,
I agree.
And like I said, the reason I voted against the Trinitas project to begin with was, I laid those reasons out, and quite frankly, if this comes back, I don't want it just out at the end of Dogtown Road or San Domingo Road or some road that's just a D or F road. I mean, right. There's going to have to be some real constraints.
Yes. Okay.
Okay,
if you want a minute order, just saying, put it on your plat.
I think this is fine in terms of direction.
Yeah, I think George has this direction, and I suspect board members will be talking to you.
Okay, we've had a request for a short break before we go on to item number 23. We will be having one closed session regarding Service Employees International, but it'll be conducted after the study session.
My computer wizard free.
Oh, man.
You have a use permit?
Pulling my leg. All right, I apologize for the lateness of the afternoon, but thank you very much for being here for this review of the housing element, and welcome to Rick. Before we launch into this, we have one item, review of correspondence, so hopefully we can make this quick, but starting with Supervisor Tryon, do you have anything to report?
I will not be in attendance at the board meeting next Tuesday, nor at COG, and Supervisor Tocanelli will cover for me at COG tomorrow evening. That's all I have to bring before the board.
Supervisor Walensky.
Half an hour ago, I had the mental health board.
Yeah, how was it?
We all should go.
We were all involved in that one.
Yes, and then, yeah, no kidding. And then I have the Amador Calaveras consensus meeting tomorrow morning, the COG meeting, which I'll be filling in for Marita on Wednesday evening at 6:30 in this very room. I have a meeting with the CCWD on the Wilseyville site on Friday, and that's it. Oh, I'm sorry. There's one other thing I wanted to announce, which is there are now going to be public meetings on the PG&E owned watershed lands. This is the Stewardship Council's meetings for this county, and there are 2 meetings in our general area, although not immediate area. We have on Wednesday, October 7th, from 3 to 6 at the Amador County Senior Center. That's 229 New York Ranch Road in Jackson. That's the first one, and it's dealing with the North Fork of the McCullamy and Lower Bear. Blue Lakes, which is the other major area out of a total of some 3,000 acres, is going to happen on Thursday, October 8th, between 3 and 5 p.m., Turtle Rock Park Community Center in Markleyville. So I don't know if anybody will be able to make that upper one, but I hope we'll have representation for the North Fork and Lower Bear.
Supervisor Toffenelli.
I will be covering for Tom for COG tomorrow night at 6:30 here. I will be.
Boy, it's going to be different.
I will be at an ATCA meeting in Jackson from 10 to 2 on Friday. That's the Amador Tuolumne County Community Action Committee that they have. And there's some talk about possibly Calaveras, Mariposa joining them. And so I'm going to attend that meeting. I had a conversation with Ted Novelli on Friday, and he's open to it. So I'm going to attend that meeting and maybe speak at the public portion of that. Also, I wanted to, hang on a second here, I wanted to bring up the fact, did anybody happen to see the cow game on Saturday? I actually watched it.
How come you weren't wearing that at the Washington game?
Well, we're you know, I don't. I am bipartisan here.
Oh, there you go. In other words, you blow in the wind depending on the results on Saturday afternoon.
Nobody's wearing blue.
Yeah, where's the Michigan hat?
I'm not doing it.
Actually, I had a Wisconsin hat, but I didn't bring it in.
I went shoe shopping.
Supervisor Toffenelli, does that conclude your comments?
That completes my comments.
Well, but wait a minute. How about the fashion? How about the fashion show on Saturday?
Pardon me?
How about the fashion show?
Yes, I am involved in Valley Springs at the Vets Hall for a benefit for that Vets Hall, their barn building committee. I will be walking models down the aisle during the fashion.
Is it going to be European swimwear that you'll be wearing? What's wrong with that?
Swimwear or
It's the same as shoes.
And that is Saturday, starting at 12 o'clock.
11:30.
11:30.
Yeah. At the Vets Hall. Okay. Supervisor Callaway, do you have comments?
I'll be at the Harvest Festival on Sunday, working the Ebbets Pass Scenic Byway booth. And I want to remind the board that Monday, Behavioral Health will be having, oh, never mind, that's in another week. Wednesday, Thursday, and Friday of this week, I'll be at the CSAC Executive Committee meeting. and the former president of the California State Association of Counties and former supervisor is sitting out there watching. So if there's anything you want to give me, Paul, for the executive officers, I think we need to talk. So I'll be there in Southern California Wednesday, Thursday, Friday. That's all.
Okay, on my board-appointed responsibilities, I'll be attending Central Sierra Economic Development Council meeting tomorrow morning in Amador County at the administration office there. Just wanted to make a comment for anybody who might be watching from the section of Rancho Calaveras that has been affected adversely by their wells going dry, what I'm calling the Dali water meeting. I made a mistake and announced that meeting would be taking place at the Jenny Lynn Firehouse like the last one, but I saw in the paper that it was advertised to be at the conference room of the CCWD training facility on, what is, my mind is fried, but Silver Rapids, that's correct. So that'll be 7 o'clock on Thursday evening, just to note the change in location. And then on Friday, I'll be going to the Mountain Counties Water Resources meeting, and I'll be holding forth along with Gary at the fashion show on 11:30 on Saturday. And also, I'd like to remind people about the Taste of Calaveras that's happening at the Dove Hill Ranch at Angels Camp on Sunday, starting at 1 o'clock going till 5. It's a very, very wonderful event. If anybody hasn't been there, I would encourage you to go. They have beautiful displays of tasty foods and wonderful artwork and some music and performance.
Some birdhouses also, don't they sell,
Birdhouse?
auction off birdhouses there?
I've never seen that happen before. Maybe I left early. Okay, Mr. Lawton, if you have do you have your notebook back there? Anything? Maybe you can just make a mental note of this. That we got a communication from CSAC concerning the selection of our board of director representatives from our county to the board of directors. We have to agendize that procedure for us. Currently, Supervisor Callaway is serving as our representative, and I'm assuming you want to continue doing that. Okay, that concludes our board report. So we can launch into our next part here. This is a study session, and we're just going to take a second to set up here. I made an executive decision. Instead of having the planning commissioners sit down there, can we fill in some chairs in between? So, planning commissioners, come on up.
That's right. So Suzanne's the only one not here.
A couple more chairs, we need like 2 more chairs up there.
Hey!
This? I should be sitting in this chair all the time.
I get the full first you got there.
My brief bag, one might be.
Park yourself.
I'd love to.
You
Is that part of your job description?
Yeah, actually I am.
This puts me up where I can see something. Sit down, I didn't need your chair.
Do we got enough chairs up there for the big chairs? We good.
No, we're good. Yeah, this is Suzanne's not with us.
Hi, Ted. Wonderful day in the neighborhood.
Claudette, you want to get a picture of all of this up here?
Yes, I am.
What are you going to do,
I'm
slam us
waiting.
in the newspaper?
I'm going to talk bad about every single one of you. I'm going to put a little caption underneath.
Okay, we'll get
Negative
close
caption.
together then.
Okay, Rick, could you introduce yourself and tell us what we're doing here?
Sure, thank you. And it's good to see you, members of the board and the planning commission, and to everybody who's been waiting patiently this afternoon. My name is Rick Keller with Interior Harnage Planning Consultants. We're out of Sacramento, and we're the firm that's involved in leading the general plan update process and also doing the housing element update. I can launch right into this, and it's a brief presentation, which I think in Calaveras County means something anywhere under 4 hours, really. So I'll keep it to that. I can guarantee I'll keep it under 4 hours. Maybe more like 20 minutes. We'll see how that works for you. So I'm going to talk about just an overview of the housing element process, since the first time was sort of addressed on all of you together in this context. And go over some of the contents of the preliminary public review draft housing element that has been released more than a month ago and that we've received comments on. We'll go over the background report as well as the policy document. We'll talk about some of the input that we've received to date in our stakeholders workshops that we've held as part of the housing element update process. And then we'll talk about next steps in the housing element process. So first of all, overview of housing element process. And for those of you who have been to the stakeholders meetings, this will be familiar, and I'll try to go through it quickly. And you can ask questions later. I can review any of this after the presentation. But we started with an initial stakeholders workshop to receive input from the community on what they thought the major housing issues were that are facing the county and some possible solutions. Then we produced we're in phase 3 right now, in which we produced a consolidated draft housing element, which consists of 2 parts, the background report as well as the policy document. We held a stakeholder workshop, the second one, last month, and right now we're at the joint board PC study session. After this, we're looking for direction from you today to send the draft with possible revisions that you recommend to the state for their review, the Department of Housing and Community Development, HCD. And then they have a review process, and we'll be getting comments back to us, and then there's a negotiation process there in terms of addressing their comments and making sure that the housing element meets state requirements. And we also have to do an environmental review process as part of that, and that'll happen during that HCD review. And then we move to the last phase, which will be public review and adoption, in which we need to hold a minimum of 2 hearings by state law to review the final draft housing element. That's the overview of where we are in the schedule for the work plan. And so the housing element requirements. The housing element is one of the 7 mandated elements of the general plan for cities and counties in California. And the schedule for the update is set by the state, and it's a 7.5-year planning period generally for the housing element, and they get updated every 5 years, and you kind of have a 2.5-year window in there. It's a little complicated, but the planning period for this housing element actually started January 1st, 2007, runs through June 30th, 2014. So we're already well into the housing element planning period, and that's in the nature of how the housing elements work. And again, the HCD reviews the element for compliance with state law, and it's the only element of the general plan that's required to be reviewed by the state for compliance with state law. And the purpose of the housing element, the broad purpose of it, is to meet the existing and projected housing needs of all the economic segments of the community and all the different subgroups that we identify in the housing element. So there are 2 components of Calaveras County's and other counties' obligation to provide affordable housing under housing element law. And the first part, the first test, is to ensure that we have adequate sites available for the allocation that the county has received, and we'll go into that in a little bit. And those, we can look at existing sites, existing vacant land, and possible redevelopable areas. And if necessary, we need to look at perhaps new sites. I'll go into the numbers, but right now, based on our numbers, and HCD will have their say, but we have adequate sites available based on existing land use designations and zoning for the projected housing needs for Calaveras County for this time period. So that's good news. And the second half of this equation is you have to ensure the adequate sites. That's the first test. Then you have to have policies and programs in place that promote affordable housing development. And there aren't sort of strict state standards for this. And so this is sort of a tricky negotiation process with HCD when they look at the kind of sum total of the policies and programs that we have in place, what's been done before, the history in the county, and make some recommendations in terms of things that they might want to see strengthened in terms of our policies and programs. And the policies and programs can address a number of different ways to try to promote affordable housing development, including regulatory incentives, removing governmental constraints, and providing funding. So those are kind of broad categories of policies and programs. And so again, the housing element contents, we have two documents, two sections that make up the whole housing element. There's a background report and a policy document. So the background report goes into existing housing needs with a resource inventory for land and funding resources, does an examination of constraints on housing, and also looks at, does an evaluation of the policies and programs from the previous housing element, which in this case was dated 2005, and looks at the success of implementing those policies and programs for the previous housing element planning period. And that gives us a starting point for the recommended goals and policies for this update. So just briefly on background report findings, and the background report is a long document. I can't remember how many pages exactly, 150, 200 pages or so. So it has a lot of detail in it. I just thought I'd highlight a few things just in terms of giving an overall picture of housing in Calaveras County. This chart here, the red, sort of muddy brownish color there, looks a little redder on my screen here, shows number of housing units in 2000, with that bluish color to the right of that showing number of housing units in 2009. And we've got this divided up into housing unit categories, housing unit types, total units being the paired left-hand columns. You can see single-family detached housing making up the vast majority of housing in the county. I think something somewhere around 85% of the total housing. And within single-family attached and multifamily apartments, and then mobile homes making up the remainder. And so you can see the growth in there with it between in that 9-year time frame, a growth of over 5,000 housing units in the county. And this chart here shows the number of existing sales of existing housing, as well as pricing for that, with the red bar on the top, on the diagonal kind of squiggly line on the top, showing median sales prices. And you can see that climbing up to a peak somewhere around fall 2006, and then declining rapidly to 2008, and rebounding a bit in the first part of 2009. So you can see median prices were up in the $400,000 range for the county, and then declining down to the sort of $250,000, $275,000 range there. And the bar chart also shows the number of sales during that period. And this is a chart that's taken from the housing element. And when we talk about different income groups in the housing element, these are the definitions that we're using. And you can see in the chart there, which ranges from the extremely low-income households, which are households that have below 30% of the area median income, up to low-income households, which are below 80% of the median income, and then the median income for a 3-person household in 2009 being $63,000. And so you can see what that means. So a low-income household, for a household of 3 persons at least, would have an annual income of about $45,000. And then the 2 columns on the right, you can see an affordable, maximum affordable monthly rent, and purchase price for housing based on those incomes. And this is using a formula that's roughly a third of income devoted, maximum a third of income devoted to housing costs. And so that kind of gives you an idea of what affordable housing costs would look like with a rent of around $1,100 a month for a low-income household of 3, with affordable purchase price of around $190,000 or so. And so you compare that to median housing prices, you can see the sort of gap that we're talking about in terms of housing prices versus incomes and affordability. And so there's plenty of more data like that and charts in the background report that you can look at. But I just present a few highlights. Now I'm going to talk about the process a little bit in terms of the assigned housing need that's been given to Calaveras County that the county is required to show it has adequate sites for. And you can see it's assignment that's coming from the top, that's coming from the state, that goes down to the various councils of government and to the county, and in this case to the unincorporated area of Calaveras County that the county government of Calaveras is required to address. And so City of Angels Camp has its own housing element that we'll be conducting for the area within incorporated Angels Camp limits. And this is the actual regional housing needs allocation. It's also termed sort of fair share of the regional housing need. And this has been assigned again from the state down through the COG to the county for the planning period ranging from start of 2007 to 2014. And it's organized by the income groups that we talked about before, with the total being on the far right. So total housing needs that the county has to meet of 2,344 units, of which, if you look at the moderate income and below units, that's 1,382. You can see the percentages there. And we'll talk a little bit about the land use designations that we're looking at for meeting that need, especially for the lower income groups. So again, here's this slide. So we have the RHNA in the middle, the regional housing need allocation, that we have to show that we have adequate sites, and then we have to have policies and programs in place to promote affordable housing development on those sites. So in terms of the density requirements, and this is looking at the lower income categories, so the low income and below, and also looking at the moderate income. For the above moderate income, that's being taken care of by moderate income housing. There's not an issue in terms of meeting the need for that in terms of land supply. And so for these, for the lower income groups, the state is looking at higher density land use categories for meeting the need for lower income households. And so these are the highest land use designations that are highest density land use designations that are in the county. There's the multifamily residential designation that allows up to 12.4 units an acre, along with multiple family residential designations in multiple community plan areas, including Arnold, Copperopolis, San Andreas, Valley Springs, that also allow up to 12.4 units an acre. So that's the sort of ceiling in terms of what your maximum density you're allowed to build at in the county, if you're not including density bonuses and those sorts of things. And this slide shows the equivalent zoning categories for that. And there are 2 zoning districts that are consistent with that. The R2 and R3 zone. R2 allowing duplexes and attached single-family units up to 12.4 units an acre, and the R3 multifamily residential that allows multifamily apartment units up to 12 units an acre. And actually, there's a little note at the bottom, but the last housing element, I think there was a program in place to increase that, or at least study an increase of possibly bumping up that maximum density on the R3 up to 18 units an acre. That wasn't done, so that's where we are now in terms of the regulations. And you see that little green box on the right there. That's the state rule of thumb for affordable housing for Calaveras County. Calaveras County is classified as a rural jurisdiction by the state. And the rule of thumb that the state has, briefly, is that if you have land use designations and zoning that allow at least up to 10 dwelling units an acre, and again, these designations and zoning that allow up to 12 units an acre meet that the state will consider those as appropriate for lower income housing. You won't have any question about that. They'll say, okay, well, you can use that in your inventory, and to the extent that you have vacant sites that have enough acreage to meet that demand, then we'll consider that as available for those households. So our inventory really concentrated on those higher density sites because, again, for the market rate housing, for the lower density stuff, we have plenty of sites available for the potential construction of market rate units. And so in our inventory, we looked at building permits that have been issued since the start of 2007, which is the start of the planning period. We looked at planned and approved projects, and we looked at vacant residential land. And the summary at the bottom is we have sufficient capacity in the county to accommodate housing for all income levels. And you can see some of the maps there. We have a big inventory in the background report that goes through the inventory on a parcel-by-parcel basis, identifies the APN number for each of the parcels, and talks about the acreage, the zoning on the sites, and notes in terms of the development feasibility for those sites. And so when the state reviews that, they're going to be going through that inventory carefully and reviewing those one by one.
Are those all residential, like
Yes.
R1s, R2s?
Yeah, these have all
None
been
of that's okay.
all residentially designated that allow for, and again, our detailed inventory focuses on the R2 and R3 sites, since just, based on what's been building permits issued so far since 2007, there are plenty of units that have actually been built at market rate to meet that part of the equation. And this table is directly from the background report, so you can locate that there in terms of the context of that. But there's 4 columns there. We're looking at lower income, which is for low income and below, low income, very low income, and extremely low income. We have the moderate income and above moderate income. And the RENA allocation is the first line, the first row. That's the RENA numbers, again, with a total of 2,344 units. And our total residential holding capacity in our inventory is well above that at 3,700. And again, we could have counted a lot more above moderate income units if we went through every vacant parcel around that. But we're focusing on the lower income. And so you can see building permits issued, planned and approved projects, and then the final line there, the final row, is the capacity on vacant land with residential designations. So for the lower income, it's the R2 and R3 stuff. And so we are meeting all of our requirements based on the inventory that we have now. And the state will review that, and we have had some comments based on our workshops and people providing some corrections to that inventory that we'll do before we submit the draft EACD. But that's where we stand right now as of the draft. And in addition to meeting the low-income housing need, we also have to show that we have appropriate zoning that provides for a variety of housing types that are identified by the state and the state law. And these range from manufactured housing to farm worker housing, emergency shelters, and second units. And there are various requirements in state law that we're addressing in the element to meet those demand for those types of housing types. And now I'm going to briefly touch on some of the major policies and programs that are in the policy document and highlight some of those. And these are ones that represent significant changes to existing policy, some of which are required by state law, in terms of state law that's changed since the 2005 element was adopted, and just other things that we've added based on community input at the stakeholders workshops and based on county staff input. So, that's kind of the source of all these. We started with the 2005 housing element as a base and have findings in the background report in terms of identifying need, the new state law requirements. We have the workshop input. So the policy document, we have 7 major topic areas in those, and those are listed there. And so all the goals, policies, and programs are organized under those 7 main topic areas. And then within those, I'm going to cover some of these topic areas and some of the major policies or programs mostly under those topic areas that I wanted to bring to your attention. And under the new residential construction topic, there's a infill incentive program that we have, and there's a minimum density standard that we're putting in, and this is calling for the amendment to the zoning code to try to limit the amount of single-family homes that are approved on the higher density land. In other words, keep that available. There are new state requirements this year have been put into place in the last year or two in state law that say if you're reducing your inventory of the higher density sites by approving lower density housing on there, you have to make findings to do that. And then if that drops you below your inventory that you need to satisfy that RENA number, you actually have to then go out and rezone. So this is designed to prevent this if possible, so you don't have to make findings every time for approving a lot of low density housing on higher density designated areas. And then under affordable housing category, we have programs addressing second units, and this is designed to bring local zoning code up to state law standards that have changed since 2005. There are also some incentive programs in there. Continuation of the first-time homebuyer program has been successful in providing funding. There's also, and I'm going to highlight this a little bit later too, but we have a program in there that's calling for a study to investigate the feasibility of inclusionary housing ordinance. And this is the one program that received the most comments during our last stakeholder workshop, and there'll be people talking about that this afternoon, and some ideas in terms of how to maybe rewrite that program. And I'll have a slide that highlights that a little bit later. And a program to encourage co-housing, cooperative housing. We have programs addressing special needs housing topics, senior housing, very important Calaveras, along with child care, and we received some good suggestions for policy and program language from the Child Care Council, and we were able to integrate some of those into the housing element. The reasonable accommodation ordinance, which is something that's required by state law, and so we've crafted a program that's been successful in other jurisdictions in terms of what the Attorney General and the HCD is looking at for what they want in the program for reasonable accommodation for persons with disabilities. Zoning for emergency shelters, this is another new state requirement that we're addressing with the new program. And we have a program in here for appointing a housing coordinator to really oversee the implementation of the housing element and to coordinate funding for the variety of housing programs and housing funding sources that are available. And that really have a sort of one-stop shop for addressing housing issues in the county. And so those are some of the major programs I wanted to bring to your attention in your discussion. And these are the key questions that we asked in workshop number 2 we had a month ago. And first question, does the housing element adequately address housing issues for Calaveras County? And are there any other policy issues that still need to be addressed? And we kind of threw those out there as questions for people to start with, and we had a wide-ranging discussion on a variety of issues. And this is the brief summary of the workshop. And there were obviously details about all this, but one of the first things we heard is just in terms of cleaning up the inventory that we had, and we're using a variety of data sources for our land inventory, including assessor's parcels data and looking at aerial photographs in terms of development feasibility for sites and using staff knowledge about these sites. We had some comments there in terms of approved projects and the details of those. We received written comments on those as well. So we'll be correcting what we have in the draft right now before we send it off to HCD. And there's also a question about making sure that we're adequately describing available water capacity or lack of capacity for certain approved project areas and certain other development areas. Again, we received a lot of comments on that program addressing the inclusionary housing study. There's a lot of talk about the housing market decline and affordability and what that means. And the sort of summary of that is that yes, housing prices have declined substantially in Calaveras. Incomes have also declined. But when the state looks at whether we're meeting this new housing need, they're really looking at the capacity for building new units. And so, unfortunately, the fact that a lot of housing is now a lot more affordable than it was doesn't really sort of count in that equation in terms of state law requirements. So, and then we had comments regarding housing coordinator and the possible recommendation for institution of a housing advisory committee along with that. And then there were questions about some of the deleted programs that we had in there, which we can address some of those, but I mean, a lot of those were programs that weren't instituted for a variety of reasons, and staff just felt were not feasible in terms of existing funding and resources. So this is, I'm sure will be a topic that we'll hear from members of the audience and from you. So this is the draft language in the policy document for that inclusionary housing study program. And so again, this is not calling for the adoption of an inclusionary housing ordinance, but this program is calling for a study to conduct to look at the feasibility of adoption. And we'll look at a wide range of issues there, and it talks about that. A lot of the comments that we're hearing is maybe we don't want to focus it just on inclusionary housing study, but look at other possible affordable housing fees and make this maybe a little more of a wider ranging study. It's kind of the summary of the comments, but we'll get some of the details on that. So I can bring this slide back up when we're discussing that topic. And then in terms of next steps and where we are in the program, what we are going to do is incorporate direction from you, from the board and the planning commission from this study session. And we'll also incorporate some of where we've been corrected in terms of mistakes in the inventory and things like that, and just sort of technical things like that. We'll be correcting all of that as well. And then producing a draft that we will then send to the state, to HCD, for their review. And so, ideally we could turn that around in the space of 2 weeks and submit it to HCD within a 2-week stretch. And then HCD has by state law, has a 60-day review period, and they'll take that full amount. And at that point, we'll get a letter that states the deficiencies that are in the element. And unfortunately, we will get that letter because we've never received a letter for any jurisdiction we worked in that, or as far as to my knowledge, nobody's ever received a letter that their first draft housing element is just good to go. So there's always, they always set the bar a little higher, and then there's a negotiation process there in terms of coming into compliance with state law. They'll eventually send us, when we complete that, they'll send us a sort of contingent approval letter, and we'll be able to then move forward with our adoption hearings. And we will have a minimum of 2 of those hearings required by state law before the element is adopted, and then it's finally, after that, submitted back to the state and it gets certified. Although at that point it's really just a formality since they've already given us the conditional approval letter. So that's where we are in the process, the quick overview. I think I said a lot there, but trying to get through this quickly since I know how your day and earlier afternoon went. So I'm happy to take any questions. And
when do we, after it comes back from HCD, at what point do we go out for public comment? So there's lots of communities, or several, that would like to comment on.
Yeah, and we have the comment on the draft to date, and our sort of main venue for comments so far has been the second stakeholders workshop that we had after the draft was released, and so people had a chance to read that and comment on it. We will be again submitting this based on your direction to HCD. At that point, there's the sort of review process with HCD. They like to involve community groups in that. We'll be meeting with HCD directly in terms of meaning county staff and Interior Harnish. But they also tend to solicit input from community groups and want to see, sort of the range of input that came in from the stakeholders workshops. And a lot of times they talk to other groups as well to get their input on, well, we're thinking of modifying this program, and what do you guys think of that? But that's more informal, really. There's not a public hearing involved at that stage. But when we do have addressed HCD comments and letters back to them, at that point, for the adoption phase, there will be a minimum of 2 adoption hearings that are required, and we can receive public input then. Of course, if we have the HCD conditional approval letter, there are a lot of things that there are changes we can make to the document, but it would be more sort of the additive type changes. In other words, if we have a program in there that HCD has looked at and approved, they don't want to see that going away then. And so the modifications that can be made would be things that sort of add to the inventory of programs to encourage more affordable housing. But our policy direction should be pretty set at that point in terms of the overall policy direction.
On our report card for the current housing, what if we don't meet our fair share? What's the ramifications to the county?
Yeah, and that's one of the biggest questions we get in terms of what's this fair share mean, and what if you don't meet it in the next housing element planning period. One important thing to remember is that this is a goal that's really designed to ensure that you have adequate sites that are available for the construction of the housing. You don't actually, as the county, it's not your responsibility to make sure that the housing gets constructed there. Now, you do have to have policies and programs in place that are going to encourage that, and the HD will approve those. But the next housing element planning period, at least the way state law is now, I mean, there's been ways to make it more strict in the future, but the way state law is now, if you come back and you don't meet your RENA allocation, and really, I mean, I don't think anybody does, because it's, I mean, the targets are so ambitious that you don't get dinged for that by the state. There's no sort of penalty for not meeting that. However, if you for whatever reason, we do have a series of quantified objectives in the programs, in the policy document, where we talk about if there's for example, the first-time home buyers program, we have a target number of households that we think we can assist with that program during the housing element planning period. If we don't meet those numbers and the quantified objectives, the state's going to want to know why. And so we'll need to explain that in the next housing element. And frankly, looking at the 2005 housing element, there were a number of programs that were in place that didn't get accomplished, and so we've had to, as part of this, sort of explain why. And so you have that reckoning in terms of explaining your progress on your existing housing element. Additionally, there is an annual reporting requirement for the housing element under state law, and although in the past that hasn't been enforced all that much, the state's really sort of cracking down on that and really wanting to see those. And so you'll have those annual reports required, which really helps you as well in terms of the county, because then, rather than sort of 5 years down the line, all of a sudden saying, oh, we didn't do anything, you're kind of checking in with the state annually, and as a reminder of the things that are committed to in the housing element.
But there's no penalty. I mean, they're not holding up highway money for it, or...
No. Yeah, the penalty, if you don't have a housing element that's in compliance with state law, if we don't get this approved by HCD, then there are penalties for certain funding programs that you're not eligible for, or you don't get the bonus points for. But if you have a certified element, then you're not missing out on those programs, and you don't get a penalty later for not meeting that arena.
I got a question. This graph here.
Sure.
These are existing units in the county. Is that what this graph reflects?
Yes, existing units. Yeah. So the difference between
the MF 5+.
Yeah.
That would be multiple family with 5 units or more, like an apartment complex.
Exactly. Yeah. 5 units or more are part of the same building.
And you're saying there's 0 in the county of those?
At least according to, these are all stats that are coming from the Department of Finance, and they publish those every year. And so at least according to those stats, if that table shows, I don't have it in front of me, let's see, if that table shows 0 in that column, that's what that's what it is.
I don't remember any apartments being built.
You know, the 0 on top, actually, the 0 on top is the change from 2000 to 2009. So the numbers like the plus 51, 52. So there's a small number.
There's a small
in there.
number, because I was going to name a few, but yes, okay.
And then
so there's
in
a
the
0 increase from...
In the background report itself, it has the actual number. So I don't have that at hand right here.
Rick, on that same slide, I think I remember saying, or hearing you say that in the 5-year period, that there was a total increase in housing of 5,000.
Yeah, that's for a 9-year period, for
9-year
2000 to 2009. Yeah.
Okay. Well, I can't remember where I got exposed to this kind of a sentiment that the housing element alluded to the fact going into that 9-year period that we should have built, our threshold should have been 1,300 affordable or moderate to affordable housing units. And how many were actually built during that time?
Oh, in terms of affordable units, you know, we talked about that in the background report, and so I don't have those numbers available right now, so I can get back to you on that one. But I mean, you know, I think the previous arena was probably for lower income was probably around that amount. And you know, I know that so maybe a little lower than that. I guess that's the moderate income below for this period. The arena assignment is 1,400. It's probably a little lower than that last time. But you know, I know those not nearly that many affordable units were built. And so you know, just a fraction of that.
Okay, but what I'm wondering about is it a reasonable expectation that out of 5,000 total units built, that there would be upwards of 1,400 of them that would be in the low to moderate price range? Is that and the way that it was presented to me is, oh my God, we haven't achieved that objective, so we're out of compliance with our housing element, and we're going to get in deep trouble. So
well, again, you know, the arena, what they're looking at is whether you have land that's appropriately zoned for that, and is also has services available, is feasible to be developed with that time frame. So really, the county's job is sort of set the table to enable this to happen. It also needs to have over here, it needs to have incentives, regulatory incentives, it needs to have funding to agree that's available. But the primary commitment when you're talking about the arena is to make sure that you have sites available. So you know, there's a lot of confusion, I think, in terms of you didn't meet the arena, now there's you're in trouble with the state, and I mean, it's sort of yes and no. I mean, they're going to look at the sort of sum total of everything that happened during this housing and planning period next time, and look at what can be improved. But there's no, as Maria was alluding to, there's no penalty for that. But if no affordable housing units are built, and we've committed to this number of units in this program, this number of units in that program, then there will be some problems.
Okay. I kind of apologize in advance for this next statement, but it is, after all, a long day. But we're going to be building some high-density housing up on the hill here, about 240 units.
Okay.
Or space for 240 people. So does that help us in this next round?
Multifamily?
It should. Yeah.
Sorry about that.
He's referring to the jail.
Yeah, there's a definition of a unit that we and that one I don't think needs a strict definition.
A little stretch, huh?
Yeah.
I'd like to ask a few questions about...
City of Folsom has asked us that as well.
That would just about cover that town, wouldn't it? I wanted to ask a few questions about the study, because I think having an inclusionary housing study doesn't really get to the point that I'd like to see us get to. The discrepancy between our goals and our achievements is pretty profound, and I don't really care whether there's the housing police that are going to come down on us. But I do care that the people that I represent have some opportunity for both themselves and their kids to somehow stay around. And we have the failure to have a multiple income level housing in the place means that we have an exodus, and that exodus actually results in community disruption. The continuity of these towns has been great through generations, and now all of a sudden, when the housing boom happened, we began losing generational continuity. So I look around the state, and there's a lot of different approaches to this. Not all of them are mandatory. There's carrots and sticks, but there are incentives. Around here, an incentive, for instance, that we might want to study would be expediting the project, getting it fast approved. That saves money in the first place, just because, well, when there's inflation, of course, we're a little not having that right now, but sooner or later we'll have a more normal economy, and the question is, at that point, what kind of incentives really do affect behavior? The private sector is going to go where it can make money, and the question is whether the public sector can provide enough incentives, at least on one level, to make a difference. But we don't really know what those would be. And I'd like to have a study that says, all right, around rural California, with similar situations, what has made a difference? And so it might be inclusionary requirements. That might be one of the things we study, but I'd sure like to see a whole lot of different incentives. We have a small program from the real estate board of realtors that took up a percentage of each house sale voluntarily could go into helping people get into a home. I've seen all kinds of different innovations, none of which have been to the scale necessary to accomplish even, I think we're at less than 1% of our goal. It would be nice to get into double digits, kind of like the transit thing that you keep talking about, but be nice to come see some improvement. So I'm hoping that we study a very broad range, and that we get that range, that the study be based on what is working in other places in the country and the state, both in terms of obligations and incentives.
Okay. Yeah, and I will call your attention to one program that we have in place under the affordable housing section, program H-2.9. It calls for incentives for affordable housing, and this is sort of the, what can we do from the planning department, building department side in terms of fee reductions, waivers, deferrals, or installment payments for development and building fees. So that's, sort of the fee side that might encourage some of that projects on the margin. So we do have that in place, but I think what you're talking about is a bit broader than that. And looking at perhaps inclusionary housing, looking at other ways to institute maybe an affordable housing fee, and other approaches that are used around California and other jurisdictions.
Well, I have a question for you, and that is, what would we have to do to meet to have an acceptable housing element that would meet the minimum requirements of the state? What does that look like? I must say I'm not really inclined to do something more than meet the minimum requirements that the state requires. I'm not for inclusionary zoning. I'm not for a housing czar in the county or a housing authority or any of those things. I think that's just just all we end up with huge advocacy groups that basically want lots of subsidies. And I'm not a big fan of subsidies when it comes to the federal or state government, but basically in housing what we do is we just take a few people that want to buy some new units and say, well, you get to pay for other people's housings, and I think that is just grossly unfair. I think it's very difficult on the middle class, who is quite frankly the one that has to carry all the burden on these kinds of programs to move into the homes of their dreams, where they're out of college and having a baby and they're working and want to buy a home, and all of a sudden they're having to pay for for homes for other people. I don't think there's any equity or justice in that whatsoever. So I'm rather curious as to what a housing element would look like for Calaveras County that would just meet the minimum state requirements that would get us by.
Yeah, that's a good question. I think, staffs, county staff, and we've been working with them, has the same concern in terms of the limitation of their resources in implementing new programs that we're proposing. And so what we tried to do is really pare down the housing element, looked at all the programs that were proposed before, a lot of ones that weren't implemented, and figure out which were the more essential ones, which were accomplishable. There are a number of programs that we had to add that are addressing new state law requirements, addressing emergency shelters, addressing second units and things like that. And so we have those in place. We have to, one of the main things we have to do, the first test, is show that we have adequate sites available, and we think we've done that. But I have to say that there isn't a sort of strict line in terms of, what's going to be adequate to the state. It differs by jurisdiction. It kind of differs by what you've done in the past. If they look at your record and say, these guys have been building a lot of affordable housing, and this has been successful. If they look at your record and say, they haven't really been meeting their obligation, and we think they need to strengthen this, and this. So that's part of why we always get these letters from HCD, and we can predict some of their comments, and some of them we can't, because they have a different take depending on the jurisdiction. So there's no really like sort of cut and dry line in terms of, we do this, we're going to meet, we're going to pass state muster. That said, I think we've done we've erred towards kind of going toward the minimum side in this document, in terms of not overcommitting county resources. I think there are a few programs that staff is maybe sort of wondering, do we have the resources for? Those are pretty minimal, I think. There might be additional requirements that the state then says, well, this is good, but you're going to need to strengthen this program, or you need to come in and add another program addressing this. So we've tried to be conservative in terms of really paring down the policies and programs to those ones that are strictly required, and those ones that we think are accomplishable, and those ones that we think will pass state muster. But it's not, we have a lot of experience in doing this across a wide variety of jurisdictions, from urban jurisdictions to rural jurisdictions all over the state. But it's on a case-by-case basis.
One question I have: all this is about basically, owning your home. I mean, one of the things that came, I think it was across the Bloomberg News ticker this morning before I came down here, either that or it was Fox News, is that the rental vacancies in apartments are at a 23-year high. Why don't we ever show apartments as housing units? Why does it always? Why do you basically have to own something in order to have housing? I mean, apartment units, it seems to me, if you can't afford housing, it's much easier to afford an apartment unit. And it's much cheaper to live in an apartment and build an apartment than it is to build a single-family residential home.
Yeah, depending on the jurisdiction and the density and everything, and looking at Calaveras, that just for whatever reason, and there are a lot of reasons, but the market has not been building those apartment units, and so we looked at there was nothing, no new units built from 2000 to 2009 in that sort of 5+ unit per building category for multifamily units. And so part of what we're looking at here is how to make sure we have land available for those type of units if there's demand for those, and part of it is figure out what sort of incentives and other things we can put in place to encourage those to be built. So look at the other stats with 43 multifamily units built from 2000 to 2009, and sort of 2 to 4 units per building. And so it's just a tiny fraction of the housing that has been built in Calaveras in the last 9 years.
Will we review the document before you send it to the state?
what we're looking at now is in terms of we've released the document and then provided it for your review. So we're looking at further direction from you that we will then integrate and send to HCD. Our work program doesn't call for us to sort of produce another draft for your review and then send it to HCD. But certainly if I'll let you guys decide whether you feel comfortable enough with sending it to the state with the direction that you add tonight.
I'm just one vote, but I don't. I would like to see the document that is going to be sent to the state prior to it going to the state, so the board knows exactly what's in it and has a chance to discuss it.
I would agree with that, but I'd like to see, instead of just, Tom has the one bear option, and I'm looking for the 3 bears option. I'd like to see something that's the bare minimum that we think we can get by with. That's what we always try to do and sometimes fail at.
We have.
I'd like to see a second kind of middle option and a third that would be a lot stronger and have a real policy discussion on what we're doing about housing. We keep doing this to ourselves, and it's not too long before we're going to be on somebody's radar and be the county that everybody loves to come and jam. I'd like to avoid that. We have enough on the radar stuff going on already, and in my view, we should try to find something that is not just the legal minimum, but something that is right to do and meets the need.
I would like to see the document before you send it to what you prepared, what's ready to go.
I don't care, because it's going to be sent back. And we can look at it.
It's going to be what? It's going to be sent back. It's going to get sent back, so we'll see.
Marita,
You think you're on
Have you no faith in the men of the board?
Well, at least in one current and one former sitting in the audience. I mean, we went through this before. Let's do the bare minimum, bare minimum. I mean, and it's like you said, you've never had a county or city get theirs by on the first go-around, so why expend the energy and time when we and then start working on it? It has to be in by when? When does the draft for discussion have to be in today?
Well, technically it's already due.
Yeah.
2 years ago.
So, I mean,
was that the 2007
Yeah.
date? Is that what we're talking about?
I guess let me just say, I mean, what's being requested, I'm not saying that they're not concerns and that I think we should discuss. But we've already asked the planning department to do a general plan. We've got ag. I mean, we have projects that we're trying to get off, and then to have them do this, they have to hurry up.
Marita, they have to do it if they're sending it to the state. All we're asking is that...
This is just a preliminary go-around.
Okay, but there's no harm, and I don't think there's any demand on planning staff to say the board would like to review it prior to it going to the state, because it has to be prepared to go to the state. So that is not an additional workload.
We will be revising the draft that you have in your hands before we send it to the state. So,
Well, I just let it go, let them comment, and then we can come back and have the discussion.
I've got a question for you, because it always is on my mind when I see these numbers.
yes.
When you come up with these, or when the state comes up with the numbers for the type of housing that's required, are they really considering what goes along with that? I mean, I've been in the county in the years that were up on that initial slide, and I know why single-family housing was so out of whack compared with the lower-income housing, because there really wasn't anything for people to work at, which were at the lower income. And it's all well and good if we say, okay, we're going to build another 200 housing projects that people can get into that aren't on the upper end of the income scale. But do they consider before they put that number on us that, where are these people going to work, or if they're not going to work, are our roads going to handle all this extra commuting that's going on?
Yeah,
Is any of that even a thought?
Yeah, I mean, in terms of the, it's coming down from the state and overall numbers, and they distribute to the regions, and they have their formula for that, and the COG does that, and they're looking at when the projected growth in communities and capacity. But some of these issues aren't addressed, and frankly, most communities, and this vast majority of communities, and there are a few exceptions that we work with in some other Central Valley towns that are have really cheap land and actually produce some sort of market rate housing that actually meets the sort of low income, moderate income definition. But the vast majority of communities in California, affordable housing is only going to be built to the extent that there is funding available for that directly. And I mean, no matter how many incentives you have in place and land available, still you need those funding programs. And so I mean that's the reality. But also the reality of state law is we kind of have to meet this requirement to show we have at least have these sites available. But yeah, I think there is we see that in a lot of communities where they might have strict growth management ordinances in place for a variety of reasons to protect farmland, protect sensitive natural areas, and a lot of times those are in direct conflict with the state's housing goals, and so it's this, you kind of have these competing demands coming down from the state, and so the housing element is just one part of that.
So they can give us the directive that we need to add 200 affordable housing or whatever the number of units turns out to be, and then it's our job to figure out how to provide police protection and make sure the road can handle the traffic and extra schooling.
Yeah, I mean the overall allocation is, and it's becoming more and more tied in now with more recent state legislation, SB 1375 and all that, that those projections are tied in with your projections in the regional transportation plan and everything else. So the housing projections shouldn't be way out of whack with what you're projecting to grow in your own planning documents. And I think in the past there's been a bit more of a disconnect, but that's getting closer together.
I guess and I'll leave this comment, I won't believe it any longer, but having seen these years that were in that initial slide in the Valley Springs area, I can tell you that's probably very legitimate where the single-family housing did explode like that, and I can also tell you that Highway 26 was never designed for the traffic that's on it now. Okay. And envisioning another growth period like that without something seriously being done to the transportation down there, as well as the schools and everything else, it's concerning.
Yeah.
Thanks for answering.
And those are the kind of issues that we're addressing and need to address in the overall general plan update too, where they're sort of beyond the scope of the housing element too.
Thank you.
Yeah.
I got a couple of questions. Just this overfull of information is really interesting in the end of the day when I'm usually kind of ready to take a break. But anyway, one of the things on your list here, on your list of thing here, I'm not sure if I'm in the right category here, and that is it 2,344 houses are required over 7 years? Is that what I see here, or is it 1,382 units or low-income houses are required?
What page are you on, Bill?
No, I don't have page numbers. So
14, slide 14.
Oh, man, where I could see that. You gotta sit next to more often.
That one?
Okay, what is that? Which one are we talking about?
Yeah, so it's the total on the end, the 2,344 units.
Okay, so that's roughly 334.8 houses a year.
Roughly.
And we're at the year actually 2010, so that's 4 years if we haven't made that category?
Well, yeah, but again, if we look down to this slide, we're counting a total of 482 units for building permits that have been issued since the start of 2007 to the start of 2009, I think, when we did that. We have
okay. So not what the question that doesn't answer me is, I don't care what happened in 2007.
Yeah.
I'm worried about what's happening from 2010, because that's not very far away, till this cutoff date of 2014.
Yeah.
Is it realistic? How many houses are required between now and then? Take away the ones we've already built.
Yeah.
And then, if I can find the notes I wrote down here, that's the number one question. And then you're saying that we're going to be skating by here if we design and mark off land for this affordable housing, no matter if the demand is there or not.
Well, the land is already designated
so we're okay on that end.
So we're okay on that.
Okay, and then the other one is, you mentioned briefly in your presentation that if somebody finds a house that is very cheap and they buy it, that's not going to cut it? It's already existing?
This is new construction, so.
Only
yeah.
new construction?
That's what they're looking at. You can
And this
actually, you can rehab houses, and if they have affordability restrictions that last, there's all sorts of technical hoops you have to jump through, but it's possible to count some of those units. But by and large, what we're talking about is, this is new housing need, and the state wants to see capacity for new units. So, again, your question in terms of what's been built, if you look at that 2344 on the right there.
Yep.
And, our number down for building permits issued, so there already been about 500 houses presumably built with building permits issued.
Well, that's how you go, by building permits only, not completion?
Well, that's the data we have in terms of how we were able to track that. So, and then we have another 1,750 units that are planned and approved and that are really scheduled to be built within this housing element planning period. So right there, that's taking up almost all of that 2,300. I mean, you're almost getting there at that point without even considering, if we're just looking at the total, this is not looking at the lower income. But if we're looking at that total, we're in terms of built and approved units, and these are tentative map approvals, I think is what our definition is for approved units there. So that already gets you close to that 2,300 total in terms of your arena.
So we don't have to do anything then?
Well, I mean,
that's what you're saying. We're already made.
According to this, we don't have to designate any land for residential development, whether higher density or otherwise.
And then the other part is that
Can I ask you a question before you
Sure.
move on from there?
Sure.
On this chart, the 1,243, the land available, does that take into consideration, slopes, infrastructure,
It
that you
does.
mentioned before? Okay.
Yeah, and so you'll see in the tables that are in the background report where we go into each of those sites on a case-by-case basis, by each parcel number, and we've reviewed those for slopes, environmental constraints, and those sorts of things. So that's and we've assumed certain density on those. We haven't assumed those are sites that could be developed up to 12 units an acre, but we've assumed that they'll be developed at 8, somewhere around there.
So there's a larger number in the background
Yes,
report where you toss some of the land out as being unsuitable.
Yeah, and so some sites aren't included in there that we looked at and just aren't included in the inventory, and other sites might have had their capacity reduced. Okay. But the state will be reviewing that as well.
See if they agree with your assessment. Yeah. Sorry, go ahead.
No, I think you got me all covered, as far as I can understand this.
Well, I had another question, and it had to do with H15, the minimum density standard, where it says basically that, the county's not going to allow single-family in R2 and R3 zoning districts. And then there's a caveat, unless built to at least 60% of the maximum density for those zones. Why that? Why the...
Well...
no, but if you do this.
Yeah, well, what that's trying to do is at least allow some single-family development in there, but saying that if it's trying to limit the stuff that's really, really low density. So we're not completely eliminating that possibility. So, working with staff, they thought that was a sort of reasonable number to pick. So, if you had 12 units an acre and you're allowing, at least 60%, then you're going to have to build it over 7 units an acre on that. So it would be smaller lot, relatively smaller lot, single-family development and multifamily development there. And what that's also trying to do is, keep the board from having to make these findings every time you're approving a development on this higher density land. It says, oh, okay, we're still in compliance with state law. So,
but it could set you up for being in a 40% deficit too, if everybody did that.
Yeah, well, it is. Although our deficit, since we're assuming are sort of 75% on average, I guess for less than that, whatever the 8 units is, I guess it's so 75%. So that's kind of our cutoff for what we're assuming the density is. So this allows some single family, doesn't completely eliminate that, but trying to reduce the really low density stuff that just takes away huge swaths of the higher density land just off the table for higher density development.
Wait a minute, I think I might have another one. Just a couple of things. These are sort of just the way, sort of the formatting of the report, and that is that in each of these programs, there's a responsible department. That's sort of my first thing. And sometimes there's more than one listed. And my experience is if you have more than one responsible party, you don't have a responsible party because it was your job or it was your job. Is it possible to have like a lead and partners or somebody whose job it really is?
Yeah, that's a good question. I think we probably listed the primary one first, but
maybe making that clear.
Yeah. And that's part of the housing coordinator position. Again,
but we may not have one,
so yeah. But in the annual housing report now, rather than letting things slide for 5 years, now it's sort of you can check in, and we have timeframes for all of those, so you can look at here's what we committed to in the first year. Did that get done? Did not? And so there's at least more of a check-in and responsibility for that. But that is an issue. We tried to have one responsible party when at all possible, but in some cases it requires building department and planning department, or it requires planning department staff to do something as well as the board to do something. So
I guess where it's obvious, it would be beneficial to designate, at least for me, I think it would be helpful to know, well, whose job really is it? Who's the go-to person?
Okay.
Related to that is the implements policies. In each of these, there's a title that says implements policies, and in every case it says to be completed. I don't really understand that. So.
Okay. Yeah, so we don't have a sort of one-on-one correspondence where every policy in the document has a corresponding program. What we do have are a number of programs under a given section that broadly implement those policies. You can see the numbering is kind of funky in the document, which we did because we're tracking against the old document. And so what we wanted to do is make that as transparent as possible for these kind of questions in terms of what's required, what's not required, what was in the previous element, what wasn't. And so we didn't want to just present you with a whole set of policies and you go, well, why is that in there? Why is that in there? Because half of them are from the previous thing that we just modified. So what we're going to do before this goes to HCD, and I guess you're going to see that draft as well, is to renumber the policies in logical. They'll be in the same order that they are now, but the numbering will follow the order. And then when we have that numbering in order, then it'll be a lot easier just to put in what and that's just kind of a reference.
So right now it's a placeholder.
It's a placeholder.
You'll show. You'll be.
Okay. One program is going to implement multiple policies, and it's designed to tie those.
Okay.
Right now it's a placeholder. So. Okay. I think it might state that in the first page of the policy document.
Okay.
But, if you're just looking at it, it's probably confusing.
One other thing, affordable housing program H29 just says the time frame is December 31st, 2006.
Yeah, we caught that one. Yeah.
We kind of missed that one.
That was, we did catch that.
Okay.
There might be other typos that we haven't caught. We didn't caught that one.
And then just to follow up something Supervisor Walensky said about, whether you call it inclusionary housing, in fee, in lieu funding for building or incentive programs. I think that in the policy that it should say not just do a study, but there should be some action related to that. Either do a study and do a draft ordinance, or do a study and present to the board for adoption or consideration or something, not just do a study.
Well, yeah, and I guess the idea is that we're not committing to any course of action, and that will come out of the study that will be presented to the board, and then the board, would ultimately make a decision for some sort of action or not. But we can try to make that as clear as possible in that program, if that's the direction we want the program to go.
Well, even if it said do a study presented to the board by the end of the time frame that you've established here.
Okay.
So it doesn't just sit there.
Okay, are there any other questions?
Well, I'm beginning to realize that I have a very nice PowerPoint summary, but no document. And so we're working at a little bit of a disadvantage not having gotten the draft.
Oh, these?
Yeah.
Yeah.
I mean, it's really nice to, I was wondering.
Yeah, here it is. I'll sell this.
I'll buy it. But
you can't afford it.
Buy one for the whole board?
You may not have known this, but when the document was released publicly, we sent both the background report and the policy document to all of you. simultaneously.
So how many months ago was that?
That was a month ago when it was released, before the first
It could have been that we were buried in golf.
It could have been. It could have been.
Was that an actual hard copy, or was it?
No.
We actually, we sent an email out, and then there was a link, but I know, there was a link.
That's not really going in.
That was
There was a link. Right, but you couldn't print it out, but there was actually a link to our website where you can retrieve the
And they
document.
gave you a printed.
This one, and they gave me this one too.
Now
Because they
I-
know I'm handicapped.
Gotta have class.
I want you to know that District 4 is fully informed.
Part of it. You have a chapter in your I can say the same about it.
Now we know why Supervisor Tryon wanted to see a draft of it, because he hasn't seen it yet.
Exactly, yes.
Supervisor Tryon, I'm shocked. I'm shocked that you didn't print one out for all of us.
You never really want one of those.
Well, let's wrap this up.
Okay.
We have additional.
He deletes
All right.
any emails from George right away.
Getting back to that sort of polling of the board that was coming this way about whether you want to see a draft, I can see why you want to see it now, Tom.
Yeah.
So, Rick, can you get a draft document for?
He's not going to see it. He's leaving tomorrow, and he will not be at board Tuesday, and it's got to get out. So it goes back to, do we all want to look at it prior to, or just let it go through the process, let them turn it down, and come back and we can
Well,
deal
suppose
with
they
it.
adopt it and we don't agree with it, then what?
Have to wait 5 years, Tom.
Well, I need to see it.
I think the board should review it. And it should get put on the agenda, even if it's an addendum for next Tuesday, and let the board comment on it. And George can sort of highlight what's being sent.
Well, I
Or
vote
Janice.
no.
Or Tom Emphysemo can come in and highlight what's in the
An
document for us.
addendum? I don't like addendums. We don't need addendums.
Oh, give,
Wait a minute.
Me a
There's
break.
5 of us here.
Well, he won't be here, so
well, that's no reason for the board to be uninformed.
Okay, I just wanted to see if anybody else is, that has been waiting patiently here wants to make any comments, so come on.
Oh, my God, he is coming. He probably has a copy of it.
Good evening. I'm here on behalf of the Calaveras Planning Coalition. I'm here to talk about affordable housing, but obviously I am not Holly Mines. Holly couldn't be here tonight, so she asked me to stop by and say thank you to the staff and to all the consultants and the members of the public who've participated in the housing element to date. She wanted me to say that the coalition appreciates the progress made so far. We feel that this housing element is more than just a nice thing to do, and it's more than just an exercise in compliance with state law. The housing element and its active and successful implementation is a key component in the county's economic recovery. Workforce housing for entry-level employees and young families will help new businesses locate here and will increase money spent here. We look forward to continuing to participate in this housing element update. Thank you. I have to go. I have to be at a meeting in Sutter Creek at 7. Thanks.
Al Segala, Taxpayer Association. I appreciate the work that's gone into this. It's quite good. And I have a copy. I got it off the internet. But I think that the taxpayers would be concerned that what comes from this is a lessening of bureaucracy and of manipulation of our local economy by government. Now, a good part of this is not that, but some things in here are pretty good. So if you can think about not creating a can of worms for the future, it would be greatly appreciated. That means our economy can grow. Our economy does not grow from the government attempting to manipulate the economy. We had the state do this with electricity. We have short memories about that. It didn't work very well. They bankrupted the utility companies. Okay, now the state wants the local counties and cities to manipulate the housing market, essentially. Okay, if this is done with a lot of wisdom, it may not do very much harm. But the more the county intrudes into the marketplace, the higher level of unintended consequences. These unintended consequences hurt people. They cost jobs, they cost prosperity, and they sometimes violate private property rights. So I would recommend using all the wisdom and the last wisdom bones in your body, use them all, and then perhaps you will not do any harm. Thank you.
Excuse me, at the risk of extending this meeting beyond my bedtime, I want to ask a question. Does the Taxpayers Association believe that it would be a manipulation of the economy for us to waive fees, expedite projects, do things that would actually benefit builders that would meet the legally required housing needs of this community?
Waiving fees, okay, taking from Peter to pay Paul, plundering this to give to them, to these other people, there's problems with that. There's unintended consequences. Expediting projects, what a beautiful thing for you to say. That should be done all the time.
So we're one out of two.
Why aren't we just doing that?
Yeah, exactly. So the taxpayers really want to have a prosperous county, and we want to have good government, which means minimum taxes and minimum regulation. And limited government. That's in the Constitution, too, also. Thank you.
Hi, Michelle.
Hi, Michelle Plotnick, and I am channeling Holly Mines. I'm the representative of her group just because she's in Spain hiking.
So there's a jurisdictional dispute about who's the real Holly Mines? Is that what's going on?
No. So it's late, we're all tired, so I'm just here to say that actually we've been quite impressed with the new draft housing element. We think it's made a lot of steps in the right direction, and we want to encourage the board to, after doing due diligence and actually maybe downloading and reading it if you can find that link, moving it on to HCD. We do have a few things that we'd like to emphasize, that we'd like to see the board do in terms of implementing it once we move past this stage, and that is create a housing czar or housing coordinator. We understand that there's not extra money in the budget for a person, but we think that somebody probably in planning could have that job, and like Fawn mentioned, it needs to be a person, because if you just sort of say this guy and this guy and this guy and this guy, no one's in charge. No one's going to be monitoring it. We're going to have some reporting requirements. Somebody's going to have to do that. We'd also like to see the board create and appoint citizens and potentially staff people, representatives of different groups, to an advisory committee who could hopefully help that person be an actual working group to help review documents, to help create the scope for the study that's mentioned. And that's probably our major concern about the draft housing element, is the call for a study of inclusionary housing. And while inclusionary housing is really sort of sounds attractive, we're not sure that it's the appropriate measure in Calaveras County in this time and place. And we'd like to see, we don't want to say don't look at inclusionary housing. We want to say look at inclusionary housing in all its potential formats. And also look at all kinds of incentive and partnership programs, and even look at the possibility of a fee program that could distribute that cost more widely across our whole community, because good housing that takes care of all the members of our community should be important to our entire community and not just to a few developers or a few people buying new homes. That burden shouldn't be simply on them. We don't see this fee as being something that's going to be huge. We're thinking a modest fee that would help fund that housing coordinator position initially. That's about it. I won't bore you since we've sent you all sorts of other information. Thanks.
Okay, anyone else wishing to make a comment? Okay, if not, I think we'd like to wrap this up. Thank you very much, Rick, for your presentation. And could you write down the link for Supervisor Tryon so that he can get the document? And
I'll resend that email actually to everybody.
Okay.
I'll print it out and give it to you, Steve.
Thanks. The problem is that my whole system collapsed twice over the last stuff on the other end.
And I want something.
If I could hold this together for just another moment or two.
Yeah, they put stuff together on rentals.
Hold on, folks, we're still
Hold
in
on,
session.
hold on, we're still in session.
Well, you have something I don't have.
Tom?
Yes, he can't go with far.
He can't hear. Mr. Lawton, is Francine still headed over? Okay. All right, so we still have a short closed session on SEIU, but before you go, please, I want to extend my appreciation for the planning commissioners to come and join us here today. We ought to do this more often.
Yes, and thank you for your patience in having to sit through our other issues.